Now, there were two cases before the High Court on the same matter. In the other case, before the other High Court, the High Court then maintains that they would not touch the case or freeze the case pending the outcome of the Supreme Court matter on a similar matter. And the implications are very interesting indeed. And I'll start with my guest in the studio. But first, tell me, first, walk us through what this means. I noticed that the OSP has a total of 8 cases they are prosecuting right now. It's very clear to me that the rice scandal case is on ice. The 7 that is left, which includes, by the way, the Akufo-Addo matter that we've talked about many times. What happens to them?
So let me explain to your viewers. I've seen people say that the court struck down the prosecutorial powers of the OSP. And I've seen some reports that are also suggestive that it did so because it reckons that that power is unconstitutional. I doubt that is what happened.
Okay, because of course, once it's unconstitutional, it's only
I doubt that is what happened. What I haven't seen the ruling, but I can imagine what happened is that the court merely interpreted the OSP's Act and came to the conclusion that on a true and proper interpretation of it, the OSP doesn't have the power to prosecute unless the Attorney General has authorized it. And indeed, when you look at Section 4 of the OSP's Act...
Let me quote it for the benefit of our audience, because it's a very important point you're making. And this is a section under the mandate of the office. 4.2 says, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. Your point is?
My point is that the court must have interpreted this provision of the Act and come to the conclusion that the OSP's office requires the authorization of the Attorney General's to enable it initiate a prosecution, and therefore, in the absence of it, then the OSP doesn't have the mandate to initiate any of the prosecutions that it is currently pursuing. And so it is not a matter of constitutionality. Neither is it a matter consequentially, right, of the striking down of any provision of the Office of the Special Prosecutors Act. It is purely an interpretation which the High Court may have done, which is within its jurisdiction. The High Court has jurisdiction in all matters, with the exception of the ones that the Constitution has given exclusively to the Supreme Court and indeed the Court of Appeal. Outside of it, the High Court has jurisdiction in all things, including but not limited to the interpretation of an Act of Parliament.
Let me give you some information from the OSP's own statement on this development in court today. That brings up the matter of constitutionality. The OSP, in the statement, part of it says, the OSP states that it is taking steps to quickly overturn the decision of the General Jurisdiction Court, since the High Court does not have jurisdiction to, in effect, strike down parts of an Act of Parliament as unconstitutional. It says, quote, it is only the Supreme Court which can strike down parts of an Act of Parliament as unconstitutional.
I will be very surprised that that is what the High Court did.
Okay, but this is the OSP statement. This is the OSP was in court, so
this is the OSP statement.
I believe they're always telling that that's what the court did.
I'm saying that, look, very respectfully. I mean, I know of instances where there have been misreporting.
But the OSP will not misreport. I mean, I find it very hard.
You see, sometimes I want to avoid personalizing matters.
Okay.
I've been in matters with the OSP where they have come and made public statements that are not reflective of what happened in court.
Okay.
Are you getting me?
Okay.
And so I am saying that I doubt if the court, because you see, there's no High Court judge in the Republic of Ghana who doesn't know that it is not its place to interpret the Constitution. There's no High Court judge. Indeed, I'll be very surprised if any High Court judge would take a constitutional perspective of Section 4.2 of the OSP Act. I'll be very surprised because it doesn't even raise a question of constitutionality. It says that subject to the Constitution, subject to, the moment a provision says subject to, it means that it submits to the authority of the Constitution. It doesn't end there. It proceeds to say that under the authorization of the Attorney General. So completely submitting that provision of the OSP's Act to the Constitution. And in this instance, Article 88. And so where is the issue of constitutionality? The issue of constitutionality doesn't arise at all. And that is why I am very cautious not to accept the rendition of the OSP.
Okay.
I want us to get the ruling itself. This is not to say that I'm completely disregarding what the OSP is saying, but I'll be very surprised that that would happen at the High Court. And I'm familiar with Justice Nyantenyadu. I've been to his court several times, from when he was in Tema to when he came to General Jurisdiction 10.
It is currently looking at the Agyeman-Rawlings case, the former the Procurement Authority boss, Charles Bisu in the case of the illegal mining and others, GS recruitment scandal, the Jabin MCE nominee who was alleged to have bribed people. You have the Northern Development Authority case. You have the Strategic Mobilization Ghana Limited, Ghana Revenue Authority. That is a case involving Ken Ofori-Atta. And that case is one of those that has so many legs, including an attempt to extradite him. And that extradition, one of the key documents there is the charges filed by the OSP in the Ghanaian court. And so the question then becomes, what does this mean for Ofori-Atta and his extradition? Two, the Tema Port Rice scandal, which is the subject of the matter, and then the MPA UPPF scandal, the MP case is the Mustafa Hamid case. Prof, what does this ruling, the verdict, mean for all these cases? Hello, Prof? Do I have Prof? Hello, Prof? Do I have Prof? Hi, Prof. Can you hear me?
I'm trying to...
Okay, great. I can hear you now. Okay, I mean, let's try and fix that. But let me put that question to so that before he gets in, once it's fixed. Once that is fixed, please alert me so I can get his thoughts on this.
If the judge will make that basic mistake, right, it's because of what I know of that judge. And, you know, I'm basically saying that, you know, if what the OSP has put out is the case, then there's a problem.
Okay.
But I doubt if that was the...
And if that isn't the case, and what you are guessing is the case, is indeed what happened, then there's no problem?
Then there's no problem.
Okay.
The problem then would be for the OSP to appeal against it or join the Supreme Court matter and hope that the Supreme Court would make a decision which effectively
will render this
one moot.
Okay, that's interesting. Now,
or overturn this, impliedly overturn this.
Until that happens, what does this mean today?
What it means today, we are all speculating.
Yes.
If what is being reported is what actually happened, then what it simply means is that the OSP would have to go to the Attorney General for a fiat to enable it continue with the prosecution. But there would be a fundamental problem.
Okay.
That fundamental problem would be whether there's the need to commence the prosecution afresh. Because to the extent that he requires the authorization of the AG to enable it initiate, commence, And to the extent that that was not in existence at the time of the initiation, the fundamental question that will confront all of us is whether or not he had the power to commence with the prosecution at all at the time he did. Unless the court is ready to interpret that to mean a mere irregularity. I doubt if that can be a mere irregularity, because it is a constitutional mandate. You either have it or you don't have it. And to the extent that you don't have it, chances are it's likely to be said that at the time you commenced the prosecution, you didn't have the power to do so. You cannot now acquire the power midway, and that can be problematic constitutionally.
And somehow, we've given some superpowers to the very person we want to divest power off. That he needs to bless us before going to a case. In fact, to be fair, I'm not a lawyer, so I don't think I didn't hear. I'm not sure I heard that part, and probably they don't read that part. But actually looking at the law now and listening to what is being discussed, it looks as though, and that's what the confusion really is. So the prosecutorial powers. So before I go ahead and prosecute someone, I have to come and beg you, get permission. Then what exactly did we do? Because see, that means the Attorney General will be more powerful. Because what it means is that he can decide that, look, he can delay you, he can probably respond or not respond. And you are just in limbo. And as the MP from Malaysia is saying, if this stands, and I hope the Supreme Court will probably do something about it, but if this stands, then clearly what it means is that all the cases the OSP are done, it's like Agyeman-Rawlings. It's like nothing happened. But it is challenging. I mean, what is sad really is that I think we have people, even at the Attorney General's office, that seem to be quite happy that this has happened. And that's where my worry really is, because it looks to me they are interested in this whole idea of dismantling the OSP, the office. I don't understand. Why are you in a haste to dismantle something that could be of help to you?
Able to deal with corruption and corruption-related cases head on without having to look in the face of a politician or a politically exposed person and say that, oh, I'm sorry, I can't do it, as has been the case. So limiting the prosecutorial powers of the OSP in this situation will be very unfortunate. So I think that as things stand, it looks like the powers of the OSP is frozen. And I'm saying frozen, I'm not sure that the status quo as has been determined by the court today should hold. And so in that sense, the way out for the OSP, in my opinion, is to go to the Supreme Court so that there will be an interpretation. And that case, probably get a case that is already there, consolidated, because under normal circumstances, the High Court should have stayed the matter and wait for that decision from the Supreme Court.
And Prof, on that point about the normal circumstances, the High Court should have stayed a decision on the matter. This same case, there are two aspects. One went to the High Court, and the other one, criminal division, and the other one went to the High Court, the division responsible for general jurisdiction, right? The criminal division stayed, put the case on ice, and says they'll await the outcome of this, pending the outcome of the Supreme Court. But then the court in the general jurisdiction decides to deliver his verdict, which said, and I'm quoting from the statement issued by the OSP, that the judge decided that the OSP lacks independent prosecutorial mandate. The judge then directed that the case be referred to the Attorney General for prosecution. In the case of the criminal division, that High Court judge simply said that
if the lawmaking process had been interpreted to include whoever presented the bill to Parliament, then possibly there could have been a creative or purposive approach by which this situation would have been cured.
In other words, if the Attorney General...
If the Attorney General had... if that had been the definition of a bill or the lawmaking process, and the Attorney General, for instance, had presented the bill to Parliament, the Supreme Court perhaps may have looked on it and said, well, the Attorney General brought this, and so he himself submitted his power, right? He himself submitted himself to Parliament to donate his power to the office of the special prosecutor.
Which really happened under the previous government.
Exactly.
But when
you look at Article 106, the lawmaking process does not include the sponsor of the bill. If it had included the sponsor of the bill, perhaps chances are would have had a different interpretation. But what we are really faced with is the fact that under Article 88 of the 1992 Constitution, the AG is given the exclusive power to initiate prosecution. Exclusive by the Constitution. The Constitution makes the Constitution the supreme law of the land. And any other law which is inconsistent with it shall be declared to be null and void, or any other act or omission. Now, this is where the problem is. The Parliament, taking cognizance of that exclusive power of the Attorney General, did not say in there that the special prosecutor is hereby given the power to prosecute. It rather said, shall be authorized. The problem, however, is the choice of word or the use of the word shall, which is then as though Parliament is mandating or compelling the Attorney General, right, to donate its power to the special prosecutor. The question is, does Parliament have that power? When power has been given to somebody by the Constitution, can he be compelled to donate that power? That is the fundamental question that confronts us.
In other words, then, if you follow your argument through, then the OSP on the back of this will have to, if he wants to continue prosecuting, will have to go for an express authorization from the Attorney General.
That's right.
To continue.
That's right. And so, if you look at the long title of the bill or the preamble, yes, the power is being given through the creation, through the deeds of Parliament, which is an act of Parliament. But the question is, does Parliament have the power to do what it did? Particularly, the power to compel the donation of prosecutorial powers.
Let me ask that question. Professor Pidita, what's your answer to that?
Well, I'm enjoying the discussion, and I think I completely agree with the Honorable MP about how he sees the powers of the Attorney General in this case, which is more or less ironclad, as found in the Constitution. And so in that case, then it means that by the word we use shall, means that power has not been given to or donated to the OSP. And so it then brings us back to the situation between the EOCO and AG. A fiat is given so that anytime you have to go to court, that fiat is given for you to be able to go to court. Yeah, but then I think we have to ask ourselves, what mischief that the OSP Act was supposed to cure? I think if we look at that, we are the AG wasn't properly exercising that prosecutorial power because it would always compromise it in the name of protecting the name and image of one of their own, which are the politicians and those who are politically exposed. So in that situation, the OSP is to be given that special function and insulation from that influence.
9 years. It was established in 2017.
Yes, yeah.
So 9 years in existence. Not many convictions. I don't think there have been more than 2 convictions. I stand to be corrected. And you have 8 cases pending in court. We need to look at the economic value of it.
Yeah.
Now we also have to look at the
CDD did that, and they came to a conclusion that value for money. Well, they checked that box.
Well, I don't know the yardstick which was used.
They did analysis on that.
If you have only 8 cases that you are doing as an office, then there's no demand. There's no demand. You see, our challenge really is that we sit down for the horse to bolt before we close the stable. And it is very difficult at that point. I've been involved in a lot of white-collar investigations, particularly since the MPP left office. I've been with a lot of clients to some of these investigative agencies. And when you go, there's one thing which is confirmed.
Okay, I need to wrap up though.
There's one thing which is confirmed. White-collar crime investigations are always very difficult. So you don't wait till it happens. You need to put in place deterrence, prevention, before you...
Bank of Africa, as strong as a group, as close as a partner.
Where Duraplas goes, water flows.
PS Industries has introduced a new roofing system known as ColorLink Plus.
Flamingo paint, simply superior. Syntax tank, are you strong? Are you tough?
Cherry Tree Properties. We develop spaces as though we were going to occupy them.
The High Court has dropped a judicial bombshell, declaring all prosecutions by the Office of the Special Prosecutor void and ordering the Attorney General to take over. Is this the death knell of the OSP or a necessary reset? Does the High Court possess the power to do what it has done? The MPP cries over the arrest of Abronya, that's the second time, and Baba Amando for speech offenses. Free speech or reckless speech? Where do we draw the line? Government cuts fuel costs, absorbing 2 cedis per litre on diesel and 36 pesos on petrol. Relief at the pumps, or just political optics? We will be right back to deal with the vexed matters on your most authoritative news analysis show. We put Ghana first. I'm Samson Ladi Anyanini.
Wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up, and in no time, our tour began. We were surrounded by wildlife from the moment we entered the Eco Park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat, undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults, this price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It's been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
Eye bribi kitwa bi na yede bo nya ye do ho ban. Ohwepa enye dede na emom eni se obenya bre ahweyie ne enioma kitwa bi a ye beye no yie.
Oja asheye she asefreme so na hwe me hu ye de biara.
Good conduct, great life is brought to you by
Indomie.
Tastes great.
More Kivo inside. Kivo Gary soaking mix. Taste of Ghana.
Yes, next. Hey, Nadia Benson, Asamo.
Me didn't tonton. Mr. Femi Kalika, just call me cockroach. Now, Mr. Femi once now.
Hey, is that you? Impruka. Yeah. Captain was key to double the action.
Me didn't sasso spray. Mr. Femi sasso quell. Yeah, go to my shasa.
Sasso, come tom preko.
The Ashesi advantage to me is one of helping people to step outside the immediate surroundings to see a big picture.
I think that the Ashesi advantage has to do with the fact that no matter where you find yourself, you are able to stand out.
One thing that helped me take up entrepreneurship was because I had been at Ashesi. The culture had encouraged us to pursue passions. The culture had encouraged us to solve problems for Africa.
Over the years, I've seen Ashesi grow into a more trusted brand that is recognized across the globe.
I think the highlight of my experience in Ashesi was its ability to impact the spirit of empathy or a sense of responsibility to people less privileged than myself.
Did you know that laser can be used to help diagnose and treat your glaucoma?
You can have modern cataract surgery like those done in Europe and America right here at the St. Thomas Eye Hospital. You can have modern phaco cataract surgery, retina detachment surgery, macular hole, and all kinds of laser surgeries done right here in Ghana. TMC or SUSU. But it's just to tell you, St. Thomas Eye Hospital provides total eye care for you and your family in a serene environment with world-class equipment.
Visit St. Thomas Eye Hospital Surgical Center at Mathaheko or their Oxford Street branch.
I say, anywhere way, Yentong. St. Thomas Eye Hospital, providing excellence in eye care.
You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And here is Samson's take. EOCO's pursuit of a member of the Council of States may due process win. Last Saturday, I shared a perspective here that was as much about the law as it was about the chilling prospects of institutional overreach. I spoke about EOCO's decision to declare a sitting member of the Council of State, Gabriel Kwamega, a wanted man. Yes, EOCO declared him a fugitive from justice, despite a High Court ruling on March 19, which effectively pulled the rug from under EOCO's feet. Since that broadcast, my attention has been drawn to a flurry of legal filings that suggest this battle is moving from the court of public opinion into a deep technical judicial trench. I've seen processes showing EOCO is not taking the High Court's ruling lying down. On March 30, they filed an application seeking to stay execution of the ruling that unfroze the bank accounts of Sisi Edem Company Limited. EOCO's appeal shows they are deeply aggrieved. Their argument, stripped of legalese, is that the court fundamentally misapprehended the facts, while Justice Richard Apietu held that the private transaction was a purely civil contractual dispute. That is to say, it was a breach of contract that had not even expired. EOCO maintains their preliminary investigations point to a criminal enterprise that the court simply overlooked. They argue that the court cannot and should not lawfully fetter the statutory investigative mandate of the state. They insist, contrary to the court's finding, that the gold deal with JG Resources Limited, worth over 57 million Ghana cedis, bears the hallmarks of fraud and money laundering. I must emphasize that the primary focus of my take last Saturday was not to determine the merits of the transaction. The focus was about non-compliance with a subsisting court ruling that rejected the claim of fraud and money laundering. In a constitutional democracy such as ours, we operate on a simple, non-negotiable hierarchy. The court makes a ruling, the state agency obeys that ruling, and if the state agency disagrees, it must resort to the same court to have the decision reversed. It cannot be issuing wanted posters while the judicial order is not suspended or overturned. You cannot claim to be enforcing the law while simultaneously showing contempt for the bench that interprets it. EOCO officials insist they have several petitions against this individual and that the reasonable suspicion threshold under their law has been met regardless of the High Court's current stance on the contractual nature of the disputes. Well, while EOCO was pursuing its application for stay of execution this week, the member of the Council of State was also busy. He secured an interim injunction from another high court. This order is a legal muzzle. It specifically prohibits EOCO from continuing its investigations, inviting him and his company, arresting him, or maintaining the wanted declaration on their platforms. Unsurprisingly, he was seen in a Durbar by the military in Ho. By law, this victory lasts only 10 days. It's a temporary ceasefire, not a final peace treaty. The parties must now prepare for the next heavyweight round, the application for interlocutory injunction. That may also stay processes for a long time. I am a lawyer in active practice for some 16 years. I know the rules just too well. Now, because this matter has become a complex web of appeals pending of the stay of execution applications and injunctions and petitions. I will pause here. Raymond Archer tells me he and his men are working in the national interest, pursuing suspects regardless of their standing in society or weight in a political party. We must let the wheels of justice turn. And that is my take. Be right back with my guest.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
Do you want a healthy smile?
Ready for a smile makeover? Hi, I'm Tanya from Bethel Dental Clinic, Ghana. Cosmetic dentistry services can enhance your smile's beauty and boost your confidence with a more attractive and radiant look. Whether you're interested in teeth whitening, veneers, or a complete smile transformation, an experienced dental team can help you achieve the smile of your dreams. The process begins with a consultation where we assess your oral health, discuss your specific concerns and goals to create a tailored treatment plan. While smile makeovers primarily focus on improving the appearance of the smile, they can also offer functional benefits such as better bite alignment, improved chewing ability, and enhanced overall health.
Healthy smile.
My name is Ochame Kwan, and Alphabet City says I should tell you about the Easter promo. So this very Easter, Alphabet City is giving out 11% discount on the full price of this beautiful semi-detached 4-bedroom. And they are saying that if you are buying within this month of Easter, because of the grace, they are going to give you free solar panels. And I repeat, free solar panels. The Easter grace is available for all. Secure your home with only 20% deposit of the full price of this beautiful home, and it's going to be yours forever. So call 0240-111-119. Alphabet City, the ABC of home sweet home.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number 1, let's bring David. Let's bring. He did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? For quality and durability, insist on Syntex pipes. If you want quality, this be where you belong. Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it dey carry water, no wahala. Syntex pipe, it dey make water dey flow. Syntex, and you're strong, and you're tough.
For the past 15 years, St. Thomas Eye Hospital has been setting the pace in Ghana's eye care landscape. In 2011, we became one of the first hospitals to introduce modern phaco surgeries, commonly called laser cataract surgeries, to Ghana. In 2013, again, we became the first eye hospital to start advanced retina detachment surgeries, macular hole surgeries, and other complex vitreoretinal procedures using the MIVS surgical approach. This year, we have set a new pace in glaucoma care with the launch of our advanced twin-star SLT-YAG combo laser, giving the glaucoma patients enhanced options in managing their conditions. We are a premier ophthalmic group practice with 11 specialist eye surgeons working together and leveraging technology to advance eye care in Ghana. We have 4 branches in Accra, Tema, and Kumasi. You may call us on 024-686-6580 or visit our website at www.stthomaseyehospital.com. St. Thomas Eye Hospital, providing excellence in eye care.
You're welcome back, and let's get right into it. My guests in the studio right now are J. Kwabena Bonfe, Junior PhD. He's lecturer at UPSA and CEO of Census. We're joined on Zoom by Maria Awalana Ada, and we have Victor Kojoga Adawudu. He's managing partner, Lord and Lord's Legal Practice, and member of the NDC Legal and Communications team. These days, he's involved in reforming the law. Kofi Bento, my good friend, the rebel, lawyer and senior vice president, Imani Africa. Nana Ejay Bafo Ewa, Rebel Plus this week. Vice chair, Subsidiary Legislation Committee, and member, Constitutional and Legal Affairs Committee of Parliament. Now, I was with you in the Supreme Court. We were sitting together and chatting. I finished my process. I was leaving. You also finished quickly. You joined me. I asked you where you were going. Say, I'm entering that place to do something. If you had told me this is what you were going to do.
Something. Something.
I would have kept you company for longer.
Something. You know, you and I have had a lot of private conversations about how I think our judiciary must be reformed. We've bottled a lot. We've bottled a lot in over a period of time.
True.
And so when you have people like us come out in the manner which we came out, you know that it's not in a vacuum.
Most unusual.
It's most unusual. It couldn't have been without provocation. You see, there was a time in the Bible, Jesus entered the temple with a whip. And for me, the best example, excellent leadership, is the leadership of Jesus Christ as a Christian. It tells you that there are times when something should be done out of character to change a system. Unless something is done out of character to change a system, then we are going to go with the status quo. Nothing will change.
True.
Nothing will change. I mean, how can you have a situation where somebody even makes a bail application and the judge can say, not in connection with the one that got me provoked, then the judge can say, we are adjourning for 2 weeks. And then adjourning for 2 weeks to rule on the bail application, and the person should go on remand. So it tells you that a lot.
We'll get to that discussion. But since I have some good lawyers here, what do you think? Some say that is an indictment on those judges. Looks like they're unprepared, or unless they are up to something deliberate. Mere bail application, and you adjourn for 2 weeks. Someone's liberty is at stake. You adjourn for 2 weeks. If you won't grant them the bail, just don't grant them. So they take a decision what next to do.
Something that is the ideal situation. That's what ought to happen. In that when you make a bail application, you can even make an oral application. You don't need to, in the first instance, to put an application in motion.
We really never. Do. It's always oral.
It is sometimes when you finish the first one, you are refused. Then the next one, you come with an application.
Right.
And these days, I think one of the things that the judges ought to be doing and must be
some of the judges.
Yes, some of the judges.
Because they are judges.
Even most.
They are judges who will not even wait to listen to you. Once the plea is taken, they say, I am minded to grant bail. These are the terms.
That is
why wait for you to talk.
Yes, exactly.
Judges.
Yes.
We shouldn't say judiciary.
That's the point.
Going forward, we should single them out
when we discuss that. That's the point I'm getting to. That you see the act of preparing and giving bench ruling, because it is presumed that the law is within your bosom. So whilst the facts you have read and you see the issues as this one, I have to grant bail. Without even the lawyer arguing, because you have read the processes already. Yeah. But where some judges would come in, they are not prepared, they've not even read, and after the ruling, whilst bail should not be used as a punishment, they come and say, okay, can we adjourn and I'll go and come. Once you know very well that while somebody is in custody, he cannot be there more than 14 days, 2 weeks. Then you ask him and you say, I'll give the ruling 2 weeks to determine whether...
You are the Law Reform Commission.
Oh, yes.
You're supposed to be reforming the law.
Exactly.
Is this one of the things that will, get your attention?
There are a lot of things.
There are rules. There are rules about how to go about it.
What I see there is the disconnection between the Law Reform Commission, the Rules of Law Committee, and Parliament. There is no coordination and complementarity.
Okay. You ensure that, Kofi.
So my brother Adaudu, this should concern you, and there's this disconnect, but work it. You see, you say bail should not be a punishment. It's a matter of rights and all the things that we know. Okay, it should be the rule that you are going to be giving bail, and the exception rather should be argued. So that's another matter. Samson, we all have been part of what you are discussing, and
the Constitutional Review Commission has actually treated this, including investigations that take forever and prosecutions that take forever. Yes. One of the proposals I put before them was that there should be timelines for prosecution. Yes. If you can't do a prosecution over 6 months,
you leave it.
You may ask for permission to get about 1 more month. If you can't finish it, let the person go.
Yes.
And investigators, as we understand, can say they are investigating you for years. They will seize your passport. There are people who are complaining about their passports being seized all over the place. And for years, they are holding on. Their life has come to a standstill.
I think Martin Prebu settles that matter.
So we are
when Benin says that there is no time frame for investigation, you cannot hold the person, so you can't just come and say investigation continues. Why did you arrange the person before court?
When you are not ready.
When you are not ready. When you have been given the power to grant bail.
We should resist the urge to give complex reasons to things when simpler reasons will suffice. And I'm saying this because, look, we are beating up the issue of why should somebody say, I'm adjourning to give a ruling on bail. It is deliberate. It's a plan. Don't give a complex reason when a simpler one will suffice. The person knows that they shouldn't do that. They are using some sort of arrangement to make sure you are remanded. Why would you adjourn for a bail hearing? And when we hear some of the things that have happened this week,
and bail is discretionary, right? Exercise of discretion.
It is discretionary.
You want to think about the discretion you want to exercise over 1 week or 2 weeks.
Exactly the point. So we here understand. Even though it's discretionary, it's a matter of rights. Should not be used as punishment and all those things. Which is why the law reform people should make sure that is the rule. The exception is what should be argued. So I'm saying, look, the judges are our friends.
Right.
All right. we sat with them in class. We give them the names of God. I tell the young people all the time, when you sit before a judge, that person is not the guy you knew. He's called my Lord. Worship. All right? Because they have the power of life and death in their hands. And for that reason, we defer a lot to them. But it is also true that sometimes they take things so far, it becomes absurd. And the simpler reasons will suffice. In this particular case, sometimes you may not like the person, and for that reason you punish them. It's not right. It is not right. Do substantive justice and let us proceed with it and let the system run.
Thank you. Doc, you've been observing this. What do you say briefly? Because people were really angry that a speech offense, which for a long time we have said there's a problem with the speech offense. Of course, we will be discussing where to draw the line because, to be frank with you, some people just abuse their right to speech. Right.
So true. So at the heart of this is the issue of public trust, which is anchored in the work and the relationship that exists between law enforcers and those who adjudicate, and in this case, the court. And all these must be seen by the people. At the heart of what is done at the executive level, the judiciary, and the legislature is how the citizenry decode what we see. Now, if we cannot have trust of fairness, of consistency, of principle from the courts, but that one would sit as my Lord, as your worship, and decide that he will look at Balfour's face and give judgment, look at Kwabena Bamfe's face and give judgment, then where do we go? And this is where I like to refer to what former Vice President of the United States, Hubert Humphrey, in his small book, this small book, The Cause is My Kind, at page 25, he says, the law can be no better than the people who are called upon to administer or obey it. So it is duty, imposed on us, especially those who have been called into the revered or elevated office of adjudication, to ensure that we can have trust in what they do. And lastly, I think it is incumbent on the bar. I mean, the judges don't cease to be members of the bar when they have, the association of the bench. So when they meet, and there is interaction between the bar and the bench at the unofficial level, what kind of conversation takes place? And this is where I think we need to nail it and make sure that we live up fairly with one another. Thank you very much.
Maybe I start with you on the OSP. Justice Eugene Nyante-Nyadu has been top in the news since, was it Thursday or Wednesday? He says, I hereby order the Attorney General to take over all prosecutions currently being handled by the OSP. That was after he had declared that the OSP does not have a warrant of the Attorney General to conduct prosecutions. And so the prosecutions it has done, the convictions it has done, they are void, and the prosecutions that are pending in the various courts, he's ordering that they should be taking over. The Attorney General says they are taking steps to do that. And in fact, they are ready to give the OSP the authorization if they apply.
First of all, this conversation that has occupied the public space within this week is, in my view, not an isolated case. Indeed, there are other issues involving the EOCO, which used to be Serious Fraud Office, that fall under the same perimeter. The FDA, GRA, immigration with powers to prosecute in their various acts that establish them. So what is happening for me is a symptom of how we are living as a people within a state. and you look at 5 key things: the law and Parliament, the occupants of office of public trust and their conduct, the Constitution as the parent law, the people generally as citizens, and then the principles that are supposed to guide us and how we somersault or flip-flop our positions with regards to that. These are the key things. But I want to precede my submission with 3 quotes. First, from Benjamin Franklin, who in 17 September 1787, at the convention that adopted the United States Constitution, after all the deliberations and the terms, he said, "On the whole, sir, I cannot help expressing a wish that every member of the convention who may still have objections to it would with me on this occasion doubt a little in his own infallibility and make manifest our unanimity, put his name to this instrument." So they came to adopt a constitution not without faults, but that they will work with it and improve upon that. Indeed, less than 5 years, in 1791, they had the first amendment. Second, Maya Angelou says in her book, How I Know Why the Caged Bird Sings, that it is not, people will remember you for not what you said or did, but how you made them feel. And lastly, the quote that I gave from Hubert Humphrey, that the law is as good as we the people. The conversation about having a separate office from the Attorney General has been going on for a very long time. I have in my hands here this lecture that was given by Vintage AKP Kluje in 2010, J.B. Dankwa Memorial Lecture. And he dealt with the Office of Attorney General at page 143. This is what he says. Of late, there have been a debate on whether the Office of Attorney General should be separated from the Office of the Minister of Justice. And he goes on to deal with, some of the issues that people have raised. Then he adds this at page 145. In Ghana, we have the tendency to blame the system whenever it does not work to our entire satisfaction. We then demand that the law be changed or the system be restructured. To me, it should not be too much whether the Office of Attorney General is unified with the Office of the Minister of Justice and held by the same person as the present arrangement ordains. What matters to me are the personalities of the main officials and their commitment to good governance, the rule of law, and advancement of the protection of fundamental human rights, human and civil rights. This is what he says. And he goes on to deal with various suggestions, including possibly electing the Attorney General at popular elections and the various nuances that are with it. Samson, if you recall, in 2018, when this OSP was being discussed, I penned an article and I made a quote, or I said something that I shared with you yesterday. And I said, we'll come to this point. Because in 1993, when the bill establishing the Serious Fraud Office was being discussed, the late Justice J.N.K. Taylor offered this article in the Legislative Alert about the unconstitutionality of the Serious Office. The arguments he advanced suffice in this conversation.
Unconstitutionality of
the Serious Fraud Office,
now
which is now
EOCO.
And they are in tandem with what is happening at the OSP. But you see, what I find strange is the unprincipled nature of some of the key actors in this matter, particularly the Attorney General, Dr. Dominic Ayine. Of course, Dr. Sremsai held brief for him in representing the Attorney General. But the key person is the Attorney General. When they were passing this bill into law, go and check the parliamentary records. His contribution to making it come to effect and be seen as curing the call for a referendum, as some of us held, because we felt that that law, in its strictest understanding, would be amending Article 88, which is entrenched.
I thought that his stance then aligns with the present position taken by the plaintiff in the suit in the Supreme Court and for which they have filed their submissions supporting that.
Which is that? Did you read about the something they call standing authorization and delegated authorization? Who introduced those words? He. And because of his academic credentials, it was taken. And that is why, if you look at his conduct, including entering nolli prosequi in some cases that he was counseled for, when he had not become Attorney General, beg of his consistency to principle. And I don't think people in public office should go that line. At the end of the day, the consistency of your arguments tell the credibility that one should have in you. Then the whole conversation about if indeed we as a people believe the office of Attorney General is not good enough to help us fight corruption, and we want to change it. Nobody forced us to adopt the Constitution in 1992, which came into force in 1993, to say that there are provisions in the Constitution that are entrenched and that you cannot amend them through parliamentary legislation or subsidiary legislation, and that you must go through a referendum. If we are so inclined or we so strongly believe that we must amend them, why don't we go through a referendum? Why the haste? And then we change it and we come full cycle in this kind of arguments. For me, I believe that we as a people have not been faithful to the Constitution and to the law. And that's why we are going around in this. Then it comes to the people who are occupying the office of Special Prosecutor today. Just this morning, I think one of the lawyers for Dr. Hamid Abdul Mustafa has contradicted a post by Samid Akum. And you wonder why the haste to put out information when you are going through a certain process of law. Should the law argued in court be put out in the media as if the courts are disabled, or if you like, not fully fit to deal with the matter head on? Must we fight the matter that should be fought in court in the media? I think that also comes to the fore. But largely, the article penned by Martin Amidu is of interest to me, which is that he is not surprised at this suit. And that even when he was invited by former President Akufo-Addo, some of the issues regarding constitutionality, he raised them. And the president assured him that, well, let's leave that to the courts to handle when they come up. And he picks or paints the picture of both the negatives and the positives in the whole conversation going on. But he picks on the Attorney General's conduct, particularly. And the courts, for declining the attempt by the OSP to join the case pending at the Supreme Court. So again, Samson, it comes up. I read the judgment of the High Court, and with the greatest respect to those who know better, I think it was an application of quo warranto, which the High Court is properly seized with to be able to pronounce on. Did he exceed his limits or his powers? I think there's a matter pending before the Supreme Court, and perhaps if the Supreme Court is minded or the attention is drawn to it, they will bring the matter to a possible conclusion. I want to conclude that at the end of the day, we as a people must choose and accept that once we have adopted constitutional democracy, the burden of democracy is fidelity to the law, even when it inconveniences us. And that nothing else can compensate for any attempt to disobey or short-circuit the process of the law. Thank you.
You mentioned the Attorney General and suggested that his position today is inconsistent with his position when the bill was being discussed, including the debate on the floor of Parliament on the 1st of November 2017. I read to you the answer, what he said.
No, it was settled.
He rose to, the Speaker asked if there was any objection to claims, suggestions that had been made, especially by Mr. Banda. Mr. Banda has said that, Mr. Speaker, I beg to move clause 4, subclause 2, line 2, before authorize, insert B. I would read 4.2, the rendition is, now he quotes, subject to clause 4 of Article 88 of the Constitution, the office shall, for the purpose of this act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. This is what you have in the law now, Section 4. Thank you. Then Dr. Ayini rose, and the Speaker asked him, any objection? This is what Dr. Ayini said. Mr. Speaker, I wanted to propose a further amendment because we have not indicated the mode of authorization by the Attorney General. So I wanted to propose that she is authorized by the appropriate legal instrument. Remember, it was Gloria Akufo who was pursuing this. General. Then Mr. Speaker, Michael Quay came in and said, where appropriate, legal process of authorization means what? Dominic returns, Mr. Speaker, for instance, she could do so by constitutional instrument or by legislative instrument. Please note that because we may return to it in the debate, in the discussion. How do you authorize the special prosecutor to prosecute? Attorney General's proposal, now Attorney General, his proposal, Dominic Ayini, was this. She could do so by constitutional instrument, that's a CI, or by legislative instrument, that is an LI, where it will spell out clearly what the jurisdiction of the Office of Special Prosecutor is. This is because what we are doing here is to say that Parliament is by statute making the Attorney General authorize the Special Prosecutor, but she is the one who is delegating that authority, and there has to be a mode of delegation. Mr. Speaker, that is the point I am making. I'll just read the Speaker's response. What kind of authorization are you anticipating again? The person has been established by an act of Parliament, and you are going to ask the Attorney General to start authorizing, bringing in matters that lawyers describe as quo warranto? Now remember that what has led to the decision now is quo warranto. It would become a big issue. By what warrant? By what authority? Let us not create unnecessary problems. If the special prosecutor is established to perform certain functions, are we intending somebody else to give him a warrant to start that which the Act of Parliament has given him, or to do, or her to do? What authorization? Let us be careful so that we do not open unnecessary Pandora's box. This is because issues of quo warranto, lawyer, you know they can be very long-winded. He said, yes, Honorable Chairman. Then he calls in Boabeng Asamoah to speak. So his position is not contrary to what he had stood for.
So what I'm saying is this. At the end of the day, they endorsed the office with all the sections in the statute that created it, which included the principle of what they called standing authorization, or delegated authorization from the agency. He was a part of that committee. And I'm saying to the extent that he was a part of that and they approved of it, I don't think the OSP Act was approved by Parliament through majority or split vote. It was unanimous. True?
Bipartisan consensus.
Exactly. So that becomes his then adopted principle or position. And I'm telling you that at the committee level, before it came to the committee of the whole, these terms of delegated authorization, how to navigate the problem of going to a referendum to amend Article 88, and I think before the Supreme Court, they will even consider whether or not that statute or that act amounts to an amendment of 88, it will all be discussed. We leave that to be discussed at the appropriate forum. All I'm saying is that as people in public trust, there must be some consistency. Okay. You cannot today go around and say that the OSP, as it exists, that you approved of, could not or cannot do what it is doing.
Unless with your fiat.
Unless with your fiat. And that's what I'm saying. And that means now coming to join those of us who held the view then that the parliamentary path that you were taking was wrong and you couldn't cure the issue we were raising.
Let's find out if the parliamentary path was in fact wrong and needs any cure. But let's not forget that what happened in the courts was not the deed of the Attorney General. It was not a case in which the Attorney General was involved. It was a special prosecutor prosecuting Archibald. And Archibald felt that the special prosecutor doesn't have the authorization.
Quo warranto, yeah.
Quo warranto, where is your authority?
Yes.
And began the inquiry.
Yes.
And led him to file an application.
And properly at the High Court.
Which the court now determined. So hold on.
No, but please, let's put it on record. Who went to defend that suit? The quo warranto. Who went? Did the Attorney General not?
Office of Special Prosecutor. It was against them, so they went to defend it. Not the Attorney General. Not the Attorney General. Okay. Yes, Kofi.
We must be clear in our mind.
Quo warranto.
It's really
you, the SP. Do you have power?
Well, yes. It's for the gentleman to use that. That's what we lawyers do. Look for something in the law to defend your client. But the bigger issues around this are principles.
Yeah.
What we must appreciate is that, especially in when reasonable people are speaking, people have different views. When you encounter a superior argument, you abandon yours. That's what Parliament is for.
See.
Parliament means a place to speak, a place to debate. People come with different ideas. So it's okay to put out the ideas, okay? But when you encounter a superior argument, what a reasonable person does is abandon theirs. Now, when you abandon your ideas, it doesn't make you a fool. It makes you better.
Sure.
But when you pick the superior argument, you don't go back to your argument. It's a matter of principle. Okay? Many people have called me and said, why am I describing Dr. Ine as my brother? I've known the man for 30 years. He's my brother. Justice I, very fine lawyer. We can disagree. It's not personal. It's not a fight. But on this matter, you and I know the position that Dr. Ine took. And he argued it very well. And he was consistent on it. But here in this Hansard report, it is clear that he met a superior argument.
And conceded.
And he conceded it. Now, we were all there. This was the main issue. The authority of the OSP against 88, it was the main issue. Why it hadn't been done in the past, why it was difficult to do, and we were all saying we should do a constitutional review, and then we said we can't wait for a constitutional review. That was the main issue.
That's right.
Yeah.
And so
here was the main issue, the memorandum. Read here and read here. You can read.
The establishment of the Office of the Special Prosecutor has become necessary in view of the institutional bottlenecks that impede the fight against corruption. Mm-hmm. The monopoly of prosecutorial authority by an Attorney General who is hired and fired by the President has been singled out by the governance experts as one of the key factors that stand in the way of using law enforcement and prosecution as a credible tool in the fight against corruption. The establishment of the office for the purpose of prosecuting corruption cases involving public officers and politically exposed persons in the performance of their functions will undoubtedly yield positive results in the number of corruption cases prosecuted. That a multi-purpose or mixed mandate agency such as the EOCO, the bill therefore seeks to vest the special prosecutor with the authority and control required. The bill seeks to vest the special prosecutor with the authority and control required to effectively investigate and prosecute cases of corruption and restore public confidence in the justice delivery system and, by extension, government. Why do we...
He just read the memorandum to the law.
So this was the main issue, all right? And we were clear-eyed about the fact that 88 was a problem. We all decided this was it. And so in writing, and Dr.
We didn't all. Some still held a view.
No. When I say we were all, I'm saying after the arguments were made, and they were not easy.
Yeah.
In civil society, everything ended up in Parliament, and you see the Speaker. The Speaker had this position. And he came to the point, and he was saying, look, let us not argue about these things. It is deemed that the person is authorized. That's the whole purpose of the thing.
Sure.
And if you leave any room, when Dr. Ina was saying, let's use the EI, CI, or whatever, we're saying if you do that, that means every time the guy is going to prosecute James Bonfair or myself or whoever, he has to go for authority. That is a total negation of the whole thing.
Independence.
So this was the issue. Superior arguments were made, and therefore, people abandoned their position. Now, you and I have sat here before, and we have talked about the attempt to remove the OSP or abandon or kill his office. And we've made the point. The people who it is aimed at are the ones trying to kill it. Now, if therefore they want to kill it, any excuse is useful.
Yeah.
So look, again I say, when a simple reason suffices, we should not strive to put complicated reasons around an issue. This has been an ongoing effort. The last one failed. All right? It came up. It went to Parliament. The president had to step in. That failed. They've come around. They are going back again at it. All right? People have made the point about the occupant of the office. That matters. Yeah. That really, really does matter. Even in the matters of bail and whatever it is. The law can be one thing, okay, but the conduct of the person gives energy, this way or that way. So that's an issue. But I think that can be resolved one way or the other. But let us be clear about this. There is no controversy. This is made up. Because this was argued, it was settled, the law was written, Section 4 is there. Yeah. And the interpretation of Section 4 is that the person has been given authority as in a running authority. Now, for interpretation, you can say it whichever way you want. So now, this has been resurrected for the purpose of achieving a certain goal, that was the status quo ante. Before the OSP, this was a status quo. AG couldn't do anything. They are stacked up with cases, and people had interference in the cases. You can't, prosecute somebody you are sitting in cabinet with, and all those other things. Then we made this point. They are going back to that thing. Why? So please, let's not confuse ourselves about some esoteric law. This is a simple matter.
Stand where Professor Akufo-Addo is, Professor H.P.C. and the likes are, that the purpose of the act is defeated if the authorization has to come by a fiat from the Attorney General. And that, in fact, apart from the purpose of the bill, of the law, sections 4 of the law, and regulation 11 of the legislative instrument, duly vest that authorization. He doesn't need any further authorization.
Yes. And all those gentlemen were part of the discussions. And they were heavy.
The judge disagrees with you.
Well, the law is in his bosom, but judges make mistakes, and sometimes they make terrible law. Very terrible law. And the name of the judge has been put there. I don't want to go into, him per se, but clearly this was wrong. And you know what? People are talking about, it was a quo-warranto issue that came.
He's not alone in that view.
No. But of course, he's not alone. But you see, judges don't make law. Parliament makes law.
They interpret the law.
They apply.
Let me finish. They don't make law. Okay? We know that even though judges don't make law, sometimes there is judge-made law.
Yeah.
Because they have certain powers.
Exactly.
I am making the same point. Maybe that judge was on that other side of the, argument.
Correct.
But once it has been debated, and sometimes people feel like the debates are unnecessary, you talk too much or whatever. This is the reason why. You beat it on the left, beat it on the right, beat it in the center, and then you draw a conclusion. You abandon the other one. And if you're a judge and you felt a certain way, once Parliament debates it and comes to a conclusion, you are duty-bound and legally bound to follow that. Now, if for any reason you made a mistake, it is for us to sit here and say, well, you made a mistake. Nobody has insulted you. This was bad. And if you are dealing with a quo-warranto issue...
My suggestion to you is that there may be as many who support your view as there may be who do not support your view and support the judge's view.
Agreed. But what I'm saying is that, you see, when you have a written institution, and that's why we have these memorandums. Okay? It gives you the thinking behind the law. That's the duty of the judge. Me as a lawyer, I will argue one narrow part in the interest of my client. But the judge, you don't like this, you don't like death sentence. Read the memorandum, read the law, read other cases, read, views of other people. And that's what I'm saying. When a superior argument is advanced, you abandon your position. Look, I keep repeating this thing about the Occupy Ghana versus Attorney General, Auditor General case. That the Supreme Court, seeing a law where the interpretation was clear that the person may exercise a certain discretion, giving all that was going on. And that is why you bring other things into the judgments you made to make them whole. Judges have to read around, okay, get a sense of it, the memorandum, etc., and bring it into the judgment. Sometimes you read a judgment and you are like, wow. I have lost cases before where I read the judgment and I'm like, this makes sense. So that was the duty of the judge. And where your co-warranto hits a constitutional issue, which was under interpretation, the Supreme Court was seized with it. You have to step back and say, hey, let the Supreme Court make that determination. So I agree that people may have different views.
The Supreme Court has been invited to make an interpretation of the Constitution.
Yes.
As regards Section 4 of the OSP Act.
Against it, yes.
In the High Court, there is no an interpretive question that came up. The judge was being simply asked to look at the Act and apply it to see whether the SP or the OSP has the warrant authority to prosecute.
Yes. And he looked at the Act.
Yes.
And like I said, he should have read the memorandum. And then he should have read the Act and seen Section 4. He should have read the LI and read them together. He should have read some of the things around. And when people talk about cases in court should not be discussed, I totally differ. The more you discuss cases, the more the judges get perspective.
No, so, that judge is now functions official.
I know. I'm making a general point. I'm saying that he should read around. The lawyer's job is to make a narrow argument. Even if he knows better, make a narrow argument in the interest of his client.
You are suggesting.
So, wait, let me finish.
You are suggesting.
No, let me finish. I haven't finished the point. When the judge read all of these things and understood them, how could he come to the conclusion? Because these things working together bring you to the irresistible conclusion. When we say irresistible, it means if you put 10 people there, 8 of them will agree in a certain direction. So how could you read all of this and come to that conclusion? Now, if you did, then we can sit here and say, I don't know how you read this.
Okay, so the point of my intervention has changed because I was going to ask you whether you were presuming that the judge has not read these, because it's obvious that in the process and in the arguments, these laws were argued by the Office of the Special Prosecutor, and the judge actually took note of them, but took a decision. Whilst those of you who say the judge's decision is application, is incongruous if you look at the whole purpose of the OSP, which is it has to be independent. It needs independence of function and prosecution. When you look at the purpose and everything else and you say his decision is incongruous with the law and the purpose,
the spirit,
you are suggesting that the judge is saying the entire law is bad. But what you read the judge say, that you may have a good law, but one small problem, how to authorize the office is the problem. So the judge may not be against the entire architecture of the law.
Because there are what we call material particulars. Every big tree has a tap root. This is the whole fulcrum of the thing. The anchor of the whole law is the authorization. And that, like I said, that's the main issue. It wasn't a tangential issue. This is what we discussed for years. We beat up, we had arguments, philosophical arguments, legal arguments, and then we all decided, look, it is not there. Okay, 88 says prosecutorial authority belongs to AG. And I'm telling you, that thing that we borrowed, some of them, these are colonial relics. In the US, they have quitam processes. Individuals can go and sue people for corruption, etc. When they win, they share the money, like whistleblower. If we were thinking about our own circumstances, etc., we'll be going that way. But we just borrowed something. And that thing, there's a reason why they got there. We had all these arguments, and then we ended up saying that, okay, we are going to give a special special prosecutor, a special authority, and it was written, described in the memorandum, written in the law, and then the LI put it out properly. We've used it for 8 years, okay? And I wonder, how come in the reliefs, he also goes back to quash previous convictions? Okay, I don't...
No power to
it gives me a sense that this person was on a mission, all right? So my point is this. He has the law in his bosom, but he has the responsibility to read broadly and widely and to explain it such that we will not have cause to sit here and say, this was a bad decision.
We'll come to interrogate the question, and I don't know if any of my other guests is going to raise that, which you just raised, and Dr. Bonfa just, made a comment that he doesn't have the power to have done so. I've heard the comment about high courts have coordinate jurisdiction. So you have one high court that is sitting on similar matters by OSP that says, as for me, I'll wait for the Supreme Court. But he decides otherwise. And some say his decision cannot bind the other high courts and so on. We'll look at that. Yes, you have been itching to make your point.
Something. There are a lot of issues arising from this. And you would not be able to get a head or tail of it unless you drill down on all these issues. This whole matter arose by reason of the originating motion that was filed. In my humble view, there was an issue of jurisdiction. On Wednesday, I had opportunity to appear on PM Express. At the time, I had not gotten some of the processes. When you look at the second relief, you see, when you have an originating motion, for the purposes of your viewers, for the benefit of your viewers, that is what invokes the jurisdiction of the court. That is what determines whether the court has the power to determine the matter or not.
When a court does not have jurisdiction, everything it does is null and void. Okay.
One of the prayers that the applicant made, that is the second relief, was on a true and proper interpretation of Article 88.
It is here. A declaration that on a proper interpretation of Article 88.4 of the 1992 Constitution and Section 4.2 of the OSP Act 2017, the OSP may prosecute only subject to and upon authorization by the Attorney General.
So that's what triggers the Supreme Court.
That is distinct from the enforcement powers of the court. They are two different things. The moment you go in for interpretation of the Constitution,
Supreme Court,
it is not within the remit of the High Court. It is within the remit of the Supreme Court, exclusive jurisdiction of the Supreme Court. I've heard people say that who said the High Court doesn't have the power to apply the Constitution. Whether or not you are going for an application is determined by the prayer or the relief you are seeking. So the moment your relief is couched in the manner of a declaration for interpretation, then the High Court doesn't have that.
The judge disagrees with you completely, and he cites plethora authority that vest him the power that this is not about interpretation, it's about application, and he's done that job. And you are by day suggesting that there is grounds for the OSP to appeal.
That's right. There is really an issue of jurisdiction. It is determined by how you couch your reliefs, because it's an originating motion. If it was a writ, and you were seeking declarations on a writ, it is within the general jurisdiction of the court. But the moment, even in that circumstance, there is a prayer for an interpretation, then of course it's not within the jurisdiction of the court. The judge may disagree, but this is my view. Indeed, if you look at even the case of Espati Kubaji, is it Kubaji? The Supreme Court, that was one of the reasons why the Supreme Court commended the Circuit Court judge for making the referral to the Supreme Court.
Yes, Raphael
Kubaji. The court didn't want to, the Circuit Court, didn't want to be caught in a controversy like this. And we are saying that, look, if it was a question of enforcement, because you had gone for Quo Warranto, Quo is to say that what power are you acting? By what power are you acting?
And by the Constitution, by our rules, the High Court has the power to issue those writs, prohibitions, quo warranto, certiorari, under its supervisory jurisdiction.
For you to have
this is what was invoked.
Quo warranto is a question. It's a question.
Where is your authority?
Where's your authority? And so if you know the authority, you wouldn't have gone and asked that question. At that point, the OSP hasn't told you the authority by which he's acting. You are saying that what authority? So wait for the OSP to tell you the authority by which he's acting. Then in your reply, you posit your argument that I contend that you don't have the authority by these acts.
In fact, this is exactly what brought this motion. Yes. Because they have sought to challenge the OSP's authority. They ask, we know that all other persons prosecuting or institutions prosecuting prosecute under the warrant of the Attorney General. Where is yours? And then the OSP said, ours is in our law. And then he said, no, that cannot be the purpose. Okay. And then they said they went to search and they found that there are executive instruments for EOCO, for all the other people, which is the fiat by the Attorney General, but there was none for the OSP. On that basis, they mounted this. So that question you have just asked, in fact, is what brought this.
So I suspect that at the point they were asking all those questions, they were doing it orally. And so now you bring a formal application. When you bring a formal application to ask that question, at that point, you don't seek interpretation. Let the OSP tell you what power it is operating with by their response. Then in your reply, you can contend and the court will rule. But when you are asking by way of a relief, you are seeking by way of a relief, an interpretative issue, I very respectfully think that it was outside the remit of the High Court by way of jurisdiction. So let's move on. With all that having been said, I still think that the Attorney General hasn't really done the nation, some fairness. And I'll tell you why. Everybody knows my position when it comes to the OSP. It's a principled position, right?
You were fighting it so it doesn't arrest your clients.
No. It's far beyond it.
Right, I get that.
It's far beyond it.
Okay.
I am looking at the economic value, and I'm ready to debate anybody on that subject.
I'll debate you after.
Don't worry. I'm ready to do that. But, Samson, when there's a proverb in Chi, you say, Yedi Jawa, ni yedi aswao. So when you take the office of the Attorney General, you take the good, the bad, and the ugly. You take the good, the bad, and the ugly. And you take a position to defend everything associated with Ghana. Okay? In 2001, 2002, thereabouts, President Akufo was the president of the Republic of this country. We all know that under the Courts Act of the Republic of Ghana and indeed the Constitution, there's only one High Court. The Chief Justice has the power to create divisions of the High Court. The Chief Justice consequently creates a division called the Fast Track High Court. It is challenged. It is declared unconstitutional by the Supreme Court. The President could have folded his hands and said that, look, after all, it's the creation of the Chief Justice. Let the judiciary defend it. They created it. But he didn't sit on his oars. He decided to go on a full throttle to defend it because it was an asset of the country. When Godfrey Dami...
How did he do that?
What? Through his Attorney General. Right?
Except the circumstances, sort of.
But the circumstances
about appointing a Supreme Court judge.
Is that new to review? He went through the process. Is that new to review? He went through the process.
No, they were fresh appointments.
No, they were necessary appointments.
They were not new appointments.
The Constitution requires that on review, The panel must be augmented.
That's right.
At that point, there were no judges.
Whatever it is, your point is made.
Yes.
He defended it.
Yes, Samson, he defended it. Right? When Godfrey Dami became that, during the
Gloria Akufo
was Attorney General, and the appointment of Martin Amidu was challenged by the current Attorney General.
Age-wise.
Age-wise. The Attorney General defended it. You see, Samson, when you look at what has happened, the OSP has been left alone in the battle. And that for me is improper. It doesn't speak well of the office of the Attorney General, especially on the back of some of the reactions that have come subsequent to the decision of the court.
Or it reveals an intention.
That the best you can do in the circumstances is to take over his cases.
It reveals an intention.
Two things.
The Attorney General didn't ask for this. Let's remember, this is an individual who went to the court.
And the Attorney General was not a party.
This is not the Attorney General.
The High Court.
This is an individual.
Consistent with this in the
The AG says
no. Was it part of the?
I just want the records. I just want the records to bear out. I just want the records to bear out that there is a gentleman by the name.
At the Supreme Court.
There's a gentleman by the name Peter Archibald Hyde who is being prosecuted and who brought this.
The public because Attorney General was not part of the case.
Nobody is saying that.
Samson,
you take your 10
I'll take my 10.
Wait, Samson, they've interrupted me. So what you say? No. I don't think Samson, I've been fair with you. But Samson, wait. This is it. All that the court said, whether we disagree or agree, whether we think that there's a jurisdictional question, it still remains the decision of the court. Whether it is of coordinate jurisdiction, it remains a decision of the High Court. Even though, as I said, it might not be binding on the other High Courts, it may be of persuasive.
It might not, or it
doesn't. It doesn't. I want to always be very cautious in how I do my analysis in the public.
So when you say it doesn't, it means that the other High Courts that are doing the prosecutions, they will continue, but the order is to the passing of the office.
It's when you
don't have the fear to continue.
You may be in contempt. And that is why it's one of the reasons why I think the court went overboard. And because of time constraints, I can't go into all these. But this is it. The court's decision, whether we like it or not, is binding on the actors. What the court decision really and truly means is that in the absence of the Attorney General's power, you can't prosecute. Fiat. You cannot prosecute. Yes. So all that it takes to cure that in the present circumstance is to give him the fiat. Now, between the giving of the OSP the fiat and the taking over of the OSP's cases, the Attorney General's immediate reaction is to take over the cases.
Reveals a lot.
Choices.
The Attorney General says, we are ready to give him the fiat, to give the office the fiat if they request.
That is where,
That was subsequent.
Wait, I'm saying. That indicates to you the intentions of the Attorney General. That fiat must not be asked in the circumstance. And what are the circumstances? The circumstance is such that the OSP is already prosecuting the cases. Cases that the OSP has investigated. Cases that the OSP knows more than the Attorney General. He understands the cases more than the Attorney General. And you say you are taking over to go and do them, understand them from the scratch, to go and do them, when the OSP is in the middle of it, between yourself and the OSP, who is much better placed to do those cases? You choose to take over those cases because of what?
As a lawyer, don't you take cases midway and prosecute them successfully?
I'm saying, already the AG's office is struggling to even deal with its own cases. And you have somebody that the state has voted a budget to work. You say that your immediate reaction, you cannot divorce this from a certain history. The OSP's crisis with this current regime started with the arrest of Martin Pebu. It was after that that senior members of the ruling party decided that the office must be abolished. Move was even made to pass a private member's bill to achieve that end. Indeed, commentaries that came in were to the effect that if you touch one, you've touched us all. And so that became it was at the heart of it. It took the intervention of the president following pressure by civil society for them to withdraw. Subsequently, we are thinking that, oh, look, something, what is going on really? People know that is to achieve a certain end. An objective that could not be achieved through the abolition, they think it can be achieved by weakening the office. Because when all it is required for the office to continue with the 8 cases that it is doing is to give it a fiat, you prefer to take over the cases. You know, there's
who tells you that the OSP is willing to accept a fiat?
I know you are playing a devil's advocate, but something. In every situation, there's a transitional process. What is the AG's transitional plan for what has even happened?
If you say the OSP should accept a fiat, does that not defeat your argument that there's no need for a fiat when you look at the way you made the law as Parliament?
I haven't come to that. I will come to that. And please.
Your time is up.
Yes, Samson, but I mean, add 2 minutes because of the interruption by my friend.
Dr. Bonfe did 14 minutes. Kofi did 14. You are on your 15th minute.
But the interruption, 3 minutes interruption. Please allow me. Quickly. Samson, 1, we need to appreciate that the Constitution is the parent law of this country.
That's right.
Any other law which is inconsistent to the Constitution, no matter the intention, no matter how well it was intentioned, will be unconstitutional. Now, if you also look at Article 93, 2 of the 1992 Constitution, Parliament's power to make laws is limited by the Constitution. And so it doesn't matter the intention. If Parliament errs, Parliament has erred. There is a fundamental problem with Section 4 of the OSP Act. Even if the court in the future would have to say that by reason of certain steps that were taken by the AG, particularly the LI, that power was given, the power which is anticipated under Article 88, 3 and 4 was given. I don't think that the court will save Section 4 of the OSP Act unless the court is prepared to consider the shall in there as may, as has happened in some cases. And I think that we may need extensive time. And so that's why I'm being very... Yeah. But my view is that Article 8 and Section 4 of the OSP Act is a compromise position that could not achieve the ends
it was negotiated.
That it was that had been hoped for.
Okay, thank you. So, Victor, I'm bringing you in now, but Dr. Bonfe has to take leave of us, so I'll give him a couple of minutes final comments, then he leaves us to continue. Of course, we have Mary Awalana Ada also on phone, on Zoom, waiting for us. But since Section 4 has been referred to too many times,
3 or 4.
Section 4 has been referred to too many times. Article 88 has been referred to too many times. Last week, I read them out. Let me read them out again for your education. Now, this is Article 88 of the 1992 Constitution. Article 88 of the 1992 Constitution says, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. 2, the Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. Now, 2 important provisions here, 3 and 4. 3, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. 4, all offenses, again, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with law. This is Section 4 of the OSP Act. It says, except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. 2. Subject to Clause 4 of Article 88. Clause 4 of Article 88. Remember, Clause 4 of Article 88 says, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with law. So, Clause 2 of subsection 2 of Section 4 of the Act says, subject to Clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses.
So by this...
And then you have a legislative instrument made in 2018, also under the hand of Gloria Akufo, the Attorney General then. That says the special prosecutor or an authorized officer shall, upon considering the facts and evidence gathered from an investigation, take a decision whether or not to prosecute. Yes.
Well, my concluding remarks on this would be that at the end of the day, a law was duly passed by Parliament.
And it's binding on this government.
And it is still part of the laws of our country until it is said to be inconsistent and null and void to that extent on the powers of the Supreme Court as Article 2 grants. That hasn't been done yet. If it will be done, I don't know. But I foretold that we'll come to this point when that act was passed, that it could be questioned, and if it was questioned, there were two scenarios that would be out. And just to crave your indulgence, Samson, this is what I wrote in 2018. I did write that we are only sitting on a time bomb for any accused person to challenge the constitutionality of the law that created the office when the special prosecutor begins his work in earnest. Whatever the outcome of such a case, the effect on the office would be dire for our constitutional process. If such a case is thrown out, it amends the Constitution regarding the amendments of entrenched clauses. If it is sustained, the whole process, time and other resources expended, would have been a waste and blow to the fight against corruption. Most often, such processes which fail the test of the rule of law are a product of political haste and attempts at populist show rather than seeking institutional transformation. I don't want to believe that my prediction then is coming to pass, but I would pray that the Supreme Court grants the OSP the chance to join that interpretation suit before them, because the Attorney General has given us every assurance.
They've ruled already.
But he can join with the latest development.
No, I'm saying that was their earlier application.
I think that's useful information.
But you can come as amicus.
Yes, it's useful.
No, he can. If there's a development, it's an interlocutory application.
They can reapply.
You can reapply.
All service organizations.
You are right. I'm saying
as amicus.
it's useful to add
better
that.
Apply as amicus.
I know
and
that.
matter.
Relax.
Bobby Banson, who
Relax.
teaches civil procedure, told us here last week that this is a new development, because at the first instance, the Attorney General said, I am the Attorney General. I can defend.
And so far it is.
And the Supreme Court said, let the Attorney General defend. Now they have realized that the Attorney General's defense is rather in support of the
applicant.
Plaintiff. So it's a new development. He can go back. The OSP can go back and ask to join.
Can go back. Hold on, I beg you. Can go back doesn't mean he has gone back. We are urging it. Number one. Number two, earlier on, there was a motion for a joiner, and it was ruled that it is not necessary for that person to join for the case to be done. So the Supreme Court actually said, no, we can go ahead without the OSP. Now, new things have happened, which mean the OSP can they choose. I'm saying all I'm saying because if you are the OSP under this kind of siege, you would advise yourself whether to proceed or not to proceed. It is proper in the interest of this country and all the things we've done that the OSP joins. So whether they like it or not, we think they should.
Thank you.
They should.
All right.
Yes. You finish.
So I'm not done. Mr. Martinamidu makes a point, and perhaps the Supreme Court of Ghana may be persuaded, I'm quoting, may be persuaded by the grounds on which the U.S. Supreme Court upheld the constitutionality of the Independent Counsel provisions of the Ethics in Government Act 1978 in Morrison versus Osmond 487 U.S. 1988. So that is an appeal to the Supreme Court for them to have, a very fair view. Samson, my comment on the issue about arrest and all these things is to make these 3 points. One, that the right to free speech is not one that is unfettered. We must be guided, we must be careful, and we must be civil in the comments that we make, not to exceed. That is one. Two, the law enforcers cannot all of a sudden attempt to bring back criminal libel law, all in the name of some people are exceeding their rights as speech. In fact, even if they exceed their rights as speech, the avenues are there through civil procedure to deal with it. And the conduct of some of our police officers, I'm saying some advisedly, is very much unbecoming. That they think because they wear the crown of the state, they can do as they please. It is not right. And sometimes the judges endorse that kind of act through some of the things that we were earlier discussing. And so I want to plead with the pleading of former President John Agyeman-Rawlings in a particular case that President Mahama's first coming, that do not kill a fly with a sledgehammer. Even though at the time, President Mahama replied in a way that was not, in my view, appropriate.
It doesn't matter that the fly can conduct itself in a way that can destabilize your society.
No matter what it is, the fly is not capable of conducting itself in that manner that will destabilize the state to the extent that you have to use a bulldozer.
Okay, so because you are commenting on this, let me ask you one straightforward question. Do you approve of the things they are accused of? Number one, Baba Amando, the accusation is that you've seen it. He went to pick the images and, use whatever AI to clad them with gay
Is that a crime?
material.
Samson.
One, do you approve of that?
I don't.
You heard Abronye's comments. Do you approve of them?
I don't.
So what do we do?
And I'm saying there are avenues in dealing with such matters to serve as a deterrent.
That is one of them.
And I'm saying it is not true the manner in which we are doing that you remember when the Akufo-Addo matter came here, we sat here and you see what I said then has come to pass. It has come to pass. Sometimes we are in a haste and we destroy ourselves. Okay. Sometimes we must be measured with the way we go about it. So lastly, Samson, we are in a World Autism Month. And next week, the Nature's Sprout Academy is doing something for the awareness. I want to say, as a disability researcher, that disability is not a taboo, neither is it a disease. It is a human condition, and we must be tolerant to dealing with it. That's it. Thank you very much for the opportunity.
Thank you very much.
And I wish you all the best.
Thank you very much. Once again, hold on briefly. Because you have finished your submissions, my attention is being drawn to something by those who have been in the office that we are talking about, not the OSP's office. They ask the question, when the nomination of the SP is done by the Attorney General, and the appointment is done by the President after vetting by Parliament, what is the implication? Do you need further authorization?
It won't cure a constitutional breach.
No. The question is...
A constitutional breach is a constitutional breach.
No.
The fact that somebody who has occupied a particular office has acquiesced to a breach It's not a defense to a breach. The fundamental question with Article...
what was you? Let's say you are Attorney General. You are picking an OSP, an SP. What are you picking them to do?
Samson, the Constitution...
What are you picking them to do?
You are picking them to go and serve in the office.
Serve by doing what?
By implementing the Act.
How?
Wait. Wait. When the Constitution says that the Constitution is the supreme law of the land, and any other law which is inconsistent with it is or an act or deed or omission is null and void.
Who determined that?
Wait.
No,
Samson. Wait.
This is supposed to be brief.
Samson. Yeah. The Constitution has given power to the Attorney General. When you look at the provision of Section 4 of the OSP Act, there's a compulsion on the Attorney General to delegate his power to the OSP. The fundamental question, which is the elephant in the room, is whether or not you can compel a constitutional office holder, somebody with a constitutional responsibility, to delegate his constitutional mandate.
Okay, so see.
It is far-reaching than we see.
The law says,
it has consequences.
The Article 88 you are referring to says he can do that delegation by setting means in accordance with law.
No, writing.
So let me do my quick.
So what's the use? Wait. So what is the use of the law? What is the use of the law? And what is the use of the... Wait. How different, okay, or which is superior? A legislative instrument, this LI, or an executive instrument, which is the fiat?
Samson.
Which is superior?
What is in issue?
Please answer my question. Which is superior?
Samson,
because when they were arguing,
what is in issue is what the legislative.
When they were arguing,
wait. Issue is Section 4.
No, let me do this. When they were arguing,
yes.
When we read Dominic Aini's comment at the time, he said, let's prescribe the mode, either by constitutional instruments or legislative instruments. This is a legislative instrument.
Correct.
Those who say the judge's decision is wrong, they are pointing that to you. It's Ankuma and the rest. They are pointing this to you.
When you look at just the legislative instrument, with the greatest of respect, you make an error. The legislative instrument sits on an act. That act, which is the Section 4, you cannot divorce it from the legislative instrument. The fundamental question is the constitutionality or otherwise of the Section 4.
So the fiat...
When you resolve the Section 4...
Please, listen carefully to yourself. I'm using a legislative instrument to do something I can use an executive instrument.
You've moved on from Section 4.
No, wait.
Have you moved on from it?
Still in Section 4.
Now.
Wait. They were discussing Section 4, where the suggestion was that use a constitutional instrument or a legislative instrument. You may say this legislative instrument, the provision is terse, it's not sufficient enough. But those who argue in favor of the fact that you don't need further authorization say that a legislative instrument like this one, signed by Gloria Akufo, Attorney General, is superior to an executive instrument, which is the fiat.
Wait.
Because this one is oversighted by Parliament.
You cannot divorce it from the Act, which is Parliament compelling the Attorney General to delegate his power. You see, when you look at Article 106 of the 1992 Constitution, the lawmaking process is not defined to include the sponsor of the bill. If it had been defined to include the sponsor of the bill, we probably have a different interpretation. This is Parliament-made law.
Thank you. Yes, Kofi.
So, for the education of the public, an executive instrument is an act of the president. It is binding on the government. When the president goes, it dies with it. A legislative instrument sits on an act, a law, statute passed by Parliament. If that law goes, that legislative instrument goes. A constitutional instrument is pursuant to the Constitution. So, point number one, an executive instrument is not binding on the next government. But a legislative instrument is binding on all government.
It is pursuant
to please, I beg you. As long as the act remains, the word compulsion has been used. It is the AG that has the power. Madam Gloria Kufu, having her power, put the law out. She went to Parliament. This idea that somebody compelled somebody, she drafted it, put it there that this person shall be authorized, and said it in a way ambulatory. It's ongoing. There were discussions which have been recorded. It is pursuant to the memorandum and the things that followed.
He's telling you that Gloria Kufu has fettered the discretion of Dominic Ayene. He shouldn't do that.
Which is why I explained that as long as this law is law, it binds all subsequent governments until you repeal it. That's why we have NRCD laws.
Where is the discretion you have given me if you have used a law to say that I have given part of it to somebody else?
That's the purpose of law. The purpose of law is not to give people discretion to do this or that. It is to tell them that after we all thinking through something, this is what must be done. Which is also why,
must be consistent.
Which is also why I think that which is why it can be. Let me finish. Let me finish. It's important to say
there is Victor, there is Mary.
If you don't like the law,
yes.
If you don't like the law, please, we are talking to the public. If you don't like the law, there is a room, there is process, and this government has 2/3. Go and repeal the law.
The president
but
said
as long as the law is
you
there,
shouldn't repeal the law.
And
that's
the
what the
point.
president
So the law is
okay,
active.
Thank you.
So you are bound by
so Victor,
no compelling.
Victor, hold on.
3 hours now.
Yes, I take a quick break. When I return, we are going to hear Victor and Mary Ada.
In Ghana, our gold is more than a resource, it's our pride. And at Gold Board Jewelry, we celebrate that pride every day with craftsmanship that reflects who we are as Ghanaians. Introducing the Gold Board Jewelry Gold Tablet, pure, certified, proudly Ghanaian gold. The best part, when you buy a Gold Board Jewelry tablet, you own it. You keep your gold with you, not with us. It's more than a jewelry. It's a smart investment for every Ghanaian who wants to secure their future. Gold Board Jewelry Gold Tablet. Own your gold. Own your future.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number 1, let's bring Baby Girl. Let's bring. You did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? For quality and durability, insist on Syntex pipes.
If you want quality, this be where you belong.
Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it dey carry water, no wahala. Syntex pipe, it dey make water dey flow. Syntex, and you're strong, and you're tough.
Excellent furnishing in a real estate business is a great deal for survival. My struggles as a young estate developer were cut short when I discovered Fernart Ghana. With quality furniture made from the finest woods and amazing after-sale service, Fernart Ghana changed my story with every single home I built. It's a one-stop shop that serves the interests of clients with a variety of living room and dining sets, solid wood kitchen installations, wardrobes, doors, cabinets, beds, pergolas, floor parquets, and many other wooden products that will last a lifetime. With Fernart Ghana, all clients are offered the opportunity to customize furniture to their specifications, and the smile on their faces says it all. Thanks to Fernart, now your home can look beautiful with furniture that would last for generations. Visit Fernart Ghana today and share my story. Locate us at Yaniba Estate, Osu, Accra, or call 0303 966085 or 055 278 4097. Think wood, think Fernart.
Yes, next. Hey, Nadia Benson, Asamo.
Me didn't tontum. Mr. Femi Kakalika, just call me cockroach. Now, Mr. Femi once now. Hey, is that you? Impruka. Yeah. Captain was key to double the action. Me didn't sasso spray. Mr. Femi sasso quell. Yeah, go to my shasa.
Sasso, come tum preko. Welcome to Malcolm, where shopping is a musical experience for all generations. Grannies, let's roll it back.
Malcolm got now we did for you. Malcolm's got it all for me and you. Life made so easy, lemon squeezy, shopping made easy. Sometimes money day, sometimes some way out of budget. Malcolm's easy. The price is right. The price is right. The price is nice. The price is nice. Fresh with the vibes, unbeatable. Do the price they fly. Do the price they fly. Your number one stop shop, number one. Your number one stop shop, Malcolm. Malcolm got now we did for you. Malcolm's got it all for me and you.
No matter the generation you belong to, Malcolm is where Ghana shops.
Bring back home the experience.
Bring home the experience.
Hi, now let me share my wildlife experience with you at Safari Valley Eco Park. Welcome to Safari Valley Eco Park. Our electric shuttle pulled up, and in no time, our tour began. We were surrounded by wildlife from the moment we entered the eco park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat, undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults, this price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It has been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
Mommy, good morning.
Oh, good morning, my son. How are you?
I'm fine, thank you, Mom. How about you?
I'm fine.
So, I just saw your mom doing her usual morning routine. Like, it was just 2 weeks she underwent a major colon surgery.
Bro, see, my mom is doing perfectly fine, and we're all excited about it. It was minimally invasive surgery, and the recovery has been very fast.
Minimally? Hey! No, wait. What do you mean by that?
So they offered my mom a laparoscopic colon surgery. Laparoscopic colon surgery, which we accepted. It turned out it was equally safe with a very fast recovery time, and the cost involved too was very, very reasonable. She was discharged 3 days after the surgery, and you can see her, she's on her feet again.
3 days?
Just 3 days, bro.
Mean Tuber Hospital, first Ghana colorectal center, aimed to serve a peculiar health need.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa, We are indeed the African bank with the global reach.
Excellent furnishing in a real estate business is a great deal for survival. My struggles as a young estate developer were cut short when I discovered Fernart Ghana. With quality furniture made from the finest woods and amazing after-sale service, Fernart Ghana changed my story with every single home I built. It's a one-stop shop that serves the interests of clients with a variety of living room and dining sets, solid wood kitchen installations, wardrobes, doors, cabinets, beds, pergolas, floor parquets, and many other wooden products that will last a lifetime. With Fernart Ghana, all clients are offered the opportunity to customize furniture to their specifications, and the smile on their faces says it all. Thanks to Fernart, now your home can look beautiful with furniture that would last for generations. Visit Fernart Ghana today and share my story. Locate us at Yaniba Estate, Osu, Accra, or call 0303 966 085 or 055 278 4097. Think wood, think Fernart.
Turn your home and office design dreams into reality. Here at Lesh Fortune, interior design is our passion. Customized interior design solutions, top of the range products such as curtains and accessories, blinds and accessories, trendy for bespoke hotel, home and office furniture, top-notch space design services.
I'm the CEO of Builders Estates. When it comes to putting the final touch on all my building projects, I look no further than Lesh Fortune for all my interior decoration needs. They bring your ideas to life.
Turning your house into a home. It's more than just accessories. You need beauty and elegance, and the expertise is very important. That's why I choose Lesh Fortune Limited, because they have experience.
Yes, indeed. With our many years of experience, we would excite you. So make that call now. Call us on 0244 265588 or 0302 811163. Lesh Fortune Limited.
Lesh Fortune Limited, unleashing luxury with perfection, one space at a time.
Lesh Fortune Limited.
Do you want a healthy smile?
Ready for a smile makeover? Hi, I'm Tanya from Bethel Dental Clinic, Ghana. Cosmetic dentistry services can enhance your smile's beauty and boost your confidence with a more attractive and radiant look. Whether you're interested in teeth whitening, veneers, or a complete smile transformation, an experienced dental team can help you achieve the smile of your dreams. The process begins with a consultation where we assess your oral health, discuss your specific concerns and goals to create a tailored treatment plan. While smile makeovers primarily focus on improving the appearance of the smile, they can also offer functional benefits such as better bite alignment, improved chewing ability, and enhanced overall health.
Healthy smile.
More important in the long title for our purposes is when you say prosecute these offenses on the authority of the Attorney General. Which Attorney General? Where then is the independence that you promised? We will say that the appointing authority, the President shall appoint the special prosecutor or a special counsel as it is in other jurisdictions with the prior approval of Parliament, and probably even further recommend with 2/3 majority, so that the person is a strong personality who is subject not just to executive nomination, but prior approval of Parliament. We also must strongly recommend that an addition to the remit of the office of the special prosecutor must be recommendations of Parliament based on the Public Accounts Committee report, so that the leakages, misappropriation, embezzlement also can directly be punished by the special prosecutor. Is an act to establish the office of the special prosecutor as a specialized agency to investigate specific areas of corruption involving public officers and politically exposed persons. Who are politically exposed persons? If you want us to subject election processes and officials engage, even political parties say so, but when you say politically exposed persons, I have a difficulty. But, Mr. Chairman, even what is more important, in the performance of their functions as well as persons in the private sector, we've roped in persons from the private sector implicated in the commission of corruption. And when you bring in the private sector, there is always an ambit, a platform to commit corruption. Nowhere in this bill is the other twin evil, bribery, mentioned. Yet they go together. One reinforces the other. And therefore, nepotism, favoritism, bribery reinforces corruption. But
its mandate directly from Article 88 of the Constitution, and that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the special prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So, what the draftsman did in Act 959 is a sort of taking that discretion and Article 88 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that will not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses.
All right, so you heard Haruna Idrisu very long ago. That was when he was minority leader. And then this process was done. And for those of you who followed the process, I'll confess, the OSP Act, the memorandum, and the processes about it, I've read them. I know them like the back of my palm, yeah? The guys who, I keep saying, who midwifed it, even though it was the Attorney General Gloria Akufo who was leading the process because it was her job, Dominic Ayene, Haruna Idrisu, Inusa Fuseni, and Mahama Yarga. These people were critical, and yet they sought to contribute to refine it, and we got it the way it is now. Of course, together with Chairman Sabonsu and his friends. Now, let's hear from Victor Agyeman-Rawlings.
And let me say that we are specifically, there are two issues on the OSP. And what we are dealing with now is the ruling that we've had from the High Court. Right. So that we do not mix the two issues. Because people are mixing the two issues and saying that the court did not have jurisdiction. No. The court actually had jurisdiction to deal with this matter. And the court does not derive its jurisdiction based on reliefs you put before.
That I disagree.
No. If you read Sangbari there, it tells you that you can couch the relief in anyhow. And I'll come to the interpretation issue.
I agree with you.
It doesn't mean that the kind of relief you have put would confer that court with jurisdiction or will not confer it with jurisdiction. The court will have to look at the relief, even if one, it does not have that relief, it can try the other reliefs.
The court will look at relief. You're still talking about relief.
Yes.
Right, he's saying is the relief.
No. So, so it is not to say that the High Court did not have. It had. And what the High Court did was to apply the law. And once he applied the law, did he have, under the law, to issue that direction order? If you look at Article 140 grants him the jurisdiction. You look at Article 141, also grants him that jurisdiction that he can issue orders, direction as to the direction that all the cases to go to the Attorney General. You may have problem with it, but did he have that legal backing?
What kind of problem is that? You may have problem with it. What kind of problem?
No, that all the cases should be taken over by Attorney General. But in the same vein, he says that they can continue to prosecute when they are given the authorization. And the good thing is that Attorney General says they are ready to issue the authorization. So I commend the judge for being bold. He was bold in applying the law to the facts. And at the center of all this was that, where is your authority? Before you prosecute, your law says that you must be authorized. Come and show that authority that you have to, and you were not able to show it.
No,
and
they showed. The court disagrees.
No. What they showed, that it was their law.
Yes, because it's a standing for them.
Yes.
The law, as you heard Kiseja being in that vetting.
Yes.
The Act, Section 4, is a standing delegation authorization.
Yes.
And then I am told that in their argument, they also refer to the LI as well.
The LI. But the court says that, based on precedent, if they say any authority, right, what they had come to see is that the EIs that have been given to other officers or institutions. So he follows the precedent and say that by his understanding, when they say Attorney General should authorize any person or institution, it should follow as the EI. That is his understanding. He might be he might be right, he might be wrong. But I think that he's been bold, he's not been timorous, and he had spoken that this is how he understands the law. You may like it, you may not like it. 2, Bafo made an argument that the Attorney General has not been fair with citizens or this nation, that they did not put in any argument against this matter.
That's what I said.
No. You said no. So
that's not what
that's why I
if you are quoting me, quote me right.
So what did you say?
I said 2 things. 1, I think that the Attorney General is not taking the necessary steps to protect the office. And I made reference to the President Kufuor's instance with the Fast Track High Court, and I made reference to Gloria Kufuor's defense of the office. I've not seen a similar spirited defense.
So his reference will be relative to the Supreme Court case.
And that's what I'm saying.
That's
what I'm saying.
Was the decision.
No, that's what I'm saying. That in the High Court matter, Attorney General was not part.
I said post the decision.
So how do you expect Attorney General to enter the matter and argue? You know, because out there, it will seem as if he knew and conveniently decided not to be part of the case. But in the actual fact, he was not part of the case in the High Court.
People are asking you is this.
Yes.
Even if the Attorney General was part, it cannot argue differently because it has already told the Supreme Court that I agree that they don't have the power.
Exactly. Now, in the Supreme Court, Samson, you're a lawyer. I'm a lawyer. When you concede to a point that is being made, does that mean that you have to, you know the truth? This is how my thinking is. This is what the thinking of the plaintiff is. And I agree, not entirely with him, but essentially I agree with him. Is that to say that I'm not putting up a forceful defense?
You are a lawyer. There are several ways of handling this matter.
No. You see, the way you want us to go is that, you see, that's had a problem, like the two examples you gave.
Because what he's saying is not far-fetched. Yes. When I started my practice earlier, and even in moderating this show, sometimes it's difficult not to take a position, and stick to it at the earlier stages. Now, I sit here and I can act with complete disinterest, but I'll moderate. When I go to court, I would have argued a narrow point and insist. But today I can go to court and say, the judge is prompting me on something. I concede.
Yes.
Yeah, you don't lose anything.
So
yeah, go on.
So are you saying that we cannot concede
whether or not there's even a constitutional question at the Supreme Court?
So it is that from what he's saying, you see, that they forcefully defended during Kufuor's time. At the end of the day, what was the backlash? What was the perception? That you were tinkling with the law, or you were trying to compromise the Supreme Court. That was why you had this verdict. And you are also, so it is for the people to look. I don't think, let the law lords speak the law, what they see. And interpretation is different, as they were talking about the memorandum and the rest. Yes, I agree. This was the law. But from day one, sometimes I can tell you, when they started with the memorandum on this law, I'm sure we met together at Alisa. I remember I was one of the representatives of the NDC with Akufo-Addo, who at the time he was the Deputy General Secretary. Some of the points that were raised up to Article 88, those are the things that is manifesting today. It was a good law. It was a good intention, but its implementation was a problem. And they knew at the time that it was an entrenched clause. They will have to go to constitutional amendment, right? The process by which they will have to go through referendum and be able to take that Article 88 and give some power to the OSP. For political expediency, they were not ready to go through that process.
It was a bipartisan consensus. What has happened to that today? That's
now,
what the
so
CSOs
if it was a bipartisan consensus, and the Constitution is supreme, are we saying for convenience that all the lawmakers and people have agreed, citizens have agreed that this is what we want, but let's bypass or circumscribe the law? And at the end of the day, we've been caught in the web.
Your point is that you are backtracking. You are changing your position for
I'm not changing my
the bipartisan consensus.
No, I'm not changing.
Okay.
I'm saying that if by bipartisan consensus, we have agreed, the lawyers, the people, everybody has agreed that let's circumvent the law. Let's be able to go and see the OSP functioning. And at the end of the day, this matter has been raised that it's unconstitutional.
Let's be careful. The bipartisan consensus was not a circumvention. Like there is some attempt to do wrong.
No, it wasn't an attempt to do wrong.
Bafo is telling you that if you took that position and agreed,
yes,
you have a duty to defend that position and not to now betray the consensus.
No. So that is why something now Supreme Court will look at the memorandum, look at all the aids to interpretation, and would give us an appropriate interpretation Just like...
But there is a betrayal of the consensus.
No, it's not a betrayal. You see,
the betrayal is that the AG is in the Supreme Court saying, I agree with the plaintiff. The OSP doesn't have authorization.
No. The executive, legislature, they have agreed. There is a consensus as to what we need to do. They make the law. Now you have brought the law to the judiciary. The judiciary is to look at it, whether this provision is consistent or inconsistent with the Constitution.
Defend your consensus position. You are not defending your consensus position.
But you see, in that consensus, where he made that there was superior arguments that were made, right? That draft or doused the argument that were being made at the time by the minority. That what was the mode of the authority? And the speaker rightly said, listen, we should not allow this quo warranto and the rest to derail the process if we look at the mode. Now the same thing has come back to that, what is the mode of the authority? And they are saying that the mode of the authority is their law. And the court is also saying that the mode of the authority should be an executive instrument.
You are referring to Speaker Michael Quay?
Yes, Speaker Michael Quay.
Did you hear him in the course of the week?
Yes.
Journalists asked him what had happened. Did you hear what he said?
Yeah, he said the judge was right. Right? So we knew the problem.
Can you compare that to what he said at the time?
Yeah. Was he being true to the principle?
There are people now that people are questioning them, and some are actually using insulting language. It's not right.
No,
you can criticize people without insulting them. Akufo-Addo has said, "Oh, we saw the problem sort of." Pemka, who was also in the AG, said, "So we saw it sort of." And then Akufo-Addo says, "I couldn't have intervened to do anything." Meanwhile, your intervention is here, clear.
Written.
All of you superintended this process.
Yes.
Then suddenly you are saying, "Oh, we knew it." How?
So if the majority knew fundamentally we had a problem, right? They were not bold to speak to it. And today, a judge is bold to say, this is a problem. Judge has said it. Now we intend to condemn him for speaking boldly to speak. He has just applied the law. And there's avenue that when maybe the Attorney General, as we are saying, can enter the matter or take it on, right? And say, this is my view. But it looks as if...
You mean the OSP or the Attorney General?
Oh, the OSP. The OSP can, with the new development, and if you look at the case of the Ghana Bar Association versus Attorney General, the Nene Amegache, their case on the issue of advice, it got to a point the Supreme Court even says that it might not be necessary that every day the Attorney General should represent other institutions when they matter. So if OSP, based on the issue where Attorney General said, I can defend the OSP, and we've seen the development now, I believe if OSP goes back based on the development or civil service organizations go in, I'm sure they will be allowed.
So call for the OSP to go back.
That decision lies with the OSP.
But you make the call.
They know the facts. They know the evidence, what they have.
The judge said,
I am an observer.
The judge said, any convictions,
that was
if any, secured by the respondent as a result of the purported exercise of prosecutorial power is hereby declared void. And I order the trial of the persons convicted to be commenced de novo by the Attorney General, pending the OSP applying to the Attorney General for its officers to be authorized to conduct criminal prosecution. The issue of the necessary executive.
If you look at the statement that Attorney General has put out, he's not concerned about these things.
No.
It's about taking over the files of the office.
No. Mention one case.
My question. Here's my question. After reading this, he declares all convictions void.
Void, yes.
Then says that AG should take over and start them all over, right?
Yes. That is where I have a little challenge.
Let's hear it.
The challenge I have is that, one, he has the right legally to make an order.
Without a
he can issue orders, he can issue direction based on Article 141, right? 141 and Section 16 of the Court Act. He has that power to issue any order to any direction. But that order and direction, you should look at the effect, and whether it will stabilize or destabilize the system. And one of the cardinal points for the court is to bring about social cohesion and also
the legal question people are asking, which is what I was actually asking.
I'm coming to that.
The legal question is, you declare that somebody didn't have the power to initiate something.
It's just like capacity. You didn't have capacity.
So void ab initio.
Void ab initio.
Meanwhile, the AG was part of some of those cases.
So you cannot be asking that something should be started because it didn't exist in the first place.
Yes.
So it's gone with the wind.
It's gone with the wind. And that was when, if you read the judgment, he comes back quickly and says that those proceedings and other proceedings, until they have authorization, then they can continue with those. But as you say, it is void by his order. Those proceedings and others are a nullity, right?
If they are a nullity, they are a nullity.
They are nullity.
They cannot be continued.
Yes, they cannot be continued. Now he says that for OSP to start any prosecution again, they should have the authorization, right? So it is not the case that OSP is being terminated or disbanded. What he's saying that, yes, it's an office. If you can investigate, you do it. But if you want to prosecute, make sure that you have an authorization.
The question,
right?
The question that arises, legal questions, are these. That's a high court. There are other high courts that are doing OSP cases, right?
Yes.
In fact, this court is not the substantive court where the case is being heard.
Exactly.
Right? So perhaps this court doesn't have an OSP matter. The question that people are asking is, in law, the other judges, are they not entitled to say, you can't say our thing is void because you don't have power over us?
Exactly. Because of their coordinate jurisdiction. So until his ruling, so he cannot bind the other high court. Until this decision...
He binds the parties.
No. Yes, but that is what he's saying. So the other court can say that, look, I'm not bound by the decision in that matter. So in anything we have to do, let's look at the interpretation that would come from the Supreme Court.
So you should have waited.
Now, was notice given to him? You see, judicial notice. No. Was notice given to him that there is some aspect that is dealing with this issue of authorization, which has to be interpreted by the Supreme Court.
If you read the ruling,
yes,
it talks about a preliminary legal objection that was raised.
Yes,
and then matters including that it is the Supreme Court that will have to deal with this.
No, let's try. Yes, no. The issue is that they wanted the interpretation, for reference to the interpretation. And that was where he said that, they said he didn't have jurisdiction to do interpretation. And he said that by Republic and Menkankan, which laid the principle that...
No, stick to your question.
No.
Your question was...
Yes.
Did the judge have notice that this matter, this portion, actually is pending before the Supreme Court? No. That's the question. That's the question.
Yes, he did not.
Really?
From my ruling in this matter.
We are told that this matter was adjourned how many times?
No. From my ruling, from the ruling I've read.
Right.
From the ruling I've read, the preliminary objection was on the interpretation.
No, the time.
Criminal objection.
The time, its first was mainly on the time the
time was
the time the supervisory jurisdiction was invoked.
Yes.
Which the law provides the timeline. They said they had gone beyond the timeline. The guy said, no, we are not looking at when he was charged. We are looking at when we discovered that
notice
that they don't have an authorization. And then the other issue.
The other one was the jurisdiction. Now, when it came to the jurisdiction, That was where he referred to Smala Bill and Menkankan and says that, yes, lawyers or human ingenuity and the rest, you can craft any relief. And that once you craft it, you would say that it's a constitutional issue and it has to be referred. And he made reference to Bonfair's case, right? No, wait. Yes, he made reference to Bonfair's case where Sofa Adinira at the time said this, if you may permit me, let me read. The real test as to whether an issue of constitutional interpretation is whether the words in the constitutional provision the court is invited to interpret are ambiguous, imprecise, and unclear, or cannot be applied unless interpreted. If it were otherwise, every conceivable case may originate in the Supreme Court by the stretch of human ingenuity and the manipulation of language to raise a tangible constitutional question. So he said clearly that he was not, but you don't craft an issue.
You have done over 20 minutes now.
Okay.
I'm going to Mariada. Gentlemen, I'm sorry. I'm not allowing any one of you to interrupt. I'm going to Mariada now. Mary, thank you very much, and thanks for your patience. You, the CSOs, now you are being blamed that you all were rushing and you were not paying attention. All you wanted was a special prosecutor, as if that was a magic wand, and you didn't have the patience for the law to be done well. What say you?
I believe that would be one of the most unfortunate conclusions that would have been arrived at by anyone. But before, let me say hello to all the other panelists and yourself in studio and those watching. We had an issue, and the challenge was navigating the fight against corruption with the current architecture we find ourselves in. And civil society had, through our advocacy and through the various researches we had done, come to the conclusion that the fight against corruption could be achieved if we had a better alternative. And that better alternative was separating the two offices, which we have not been able to achieve because of the issues around constitutionality and all the instances the lawyers have been espousing for the past almost 2 hours. So what was the other good practice or the consensus position we could come to ensure that we didn't allow the plundering of the state to go unnoticed or to go unpunished? We did an extensive research, and Samson, you were part of this, if not from the beginning, perhaps somewhere along the line. And we came to the conclusion that some offices exist in other jurisdictions which were doing a good job. And apart from that, if you looked at the NACAP, first NACAP document, it proposed something along the lines of an independent
National Anti-Corruption Action Plan.
Yes, the NACAP proposed an independent prosecutor, not what we have now. And that NACAP was originally initiated by the current president. And it went through the processes, getting all our support and putting in this document to ensure that we fight corruption very well. Unfortunately, we didn't get that. We had manifestos come up where the past president, Nana Addo Dankwa Akufo-Addo, suggested the office of the special prosecutor, which I must say was not similar to what the NACAP wanted, but they were supposed to be killing the same bird. And so civil society believed that to ensure that this happened, we needed to support the process and not to support it hook, line, and sinker. We came up with evidence, research that puts together this law, and we support it and still believe that until such a time that we are able to navigate the challenges of the Constitution, this was the best bargain we could come up with. Unfortunately, some of the proposals we made, which were not accepted, if they were accepted, would have cured some of these mischief that is currently being perpetuated. We agreed that there was no way we would have this independent office without dealing with the issues around Article 88.4. And so our proposal originally was to ensure that we have a constitutional instrument, if not whatever the case may be, to ensure that we have some stability. But the persons you have mentioned earlier, who were part of this discussion, who stood against some of the proposals civil society came up with, we came to a consensus because we believed without a doubt at the time that we needed something else, because the fight against corruption was being done post-regime, and post-regime accountability is not exhaustive enough. We thought we should have a wholesale in-regime, post-regime accountability regime that deals with anti-corruption. And we came to consensus. The Honorable Banda, who was the chair of the Legal, Constitutional and Parliamentary Affairs Committee of Parliament at the time, and all the committee members and others who came to join in, including civil society as a coalition, believed that this was the way to go. And we did same with ensuring that we have a law to fight corruption. And over the past 8 years, Samson, let me say that even though we have not had a perfect structure, we have seen some gains. And let me quickly bring in the assessment which was recently done, which you moderated the session so perfectly on. Some of the issues that came up, which citizens continue to believe and which civil society believes is credible and must be thought of, is the fact that citizens believe that the OSP continues to remain relevant if the executive allows it to be so. And citizens believe strongly that 77.7% of the citizens who were surveyed believe that anti-corruption or the independent office should not be controlled by government. If it is not, then it means it is going to do a good job. Let me again add that the citizens believe that when they were asked, which office do they believe at this current jurisdiction that we are implementing, who is the best institution to fight corruption? 55.2% of the citizens indicated that the office of the special prosecutor was the best place to go to if you wanted to fight corruption through investigation, through prosecution, and going the whole route. It is not for the lack of institutions, because we see that the second institution was also cited as SHRAJ, because SHRAJ currently has a constitutional mandate, which we have espoused and advocated for over close to 2 decades, if it is not more than that. Samson, an office through this analysis indicated that in its short lifespan has received and is pursuing some 130 cases. Can we, which are corruption and corruption related, the same office which we are talking about not prosecuting and making a toothless bulldog now, as per the ruling of the judge, has between 2024 and 2025 moved from the initial 27 cases to 167 in just a year, because it is now set up. I say in just a year because it is now being fully set up after the initial issues of they not getting the funding and others to set up fully. The same office has, within a short period, recovered about 35 million of the time and prevented or averted some losses of 7.18 billion Ghana cedis. Are we saying that through what we want to do, and let me say it's not just this government, it started in the previous administration when they realized that the monster they had created was going after them. And I can mention cases here which I don't want to mention. And they also started with the court cases, which has the intention of distracting from the achievement of the object of the office. We have seen that the government itself, which set it up, decided that it had outlived its usefulness and wanted to get them out through some assigns of them going to court. But the unfortunate aspect of the whole discussion now for me is the fact that this current government, which has indicated that corruption is a no-go area for them and they would prosecute corruption without fear or favor, is being embroiled in this discussion. I say so because, number one, the president has assured us that corruption remains one of his key 4 pillars that he wants to prosecute. And so, when the majority leader and the chief whip decided that they were going through legislation to repeal the act and so then disband the office, I saw that perhaps rhetoric sometimes, and then sometimes when people concede to issues maybe they are not believing in, when they have the opportunity, they show their true colors. And this is one of the instances. And again, all the other instances that we are currently talking about, which is distracting the office from prosecuting its agenda, which is per its object to investigate corruption and corruption-related offenses, to investigate corruption-related offenses which have to do with procurement, and then to also ensure that they are working on asset recovery and ensuring that they are also working in preventing corruption is thwarted, is unfortunate. I believe that without a doubt, for Ghana, at this particular time, and for civil society, the evidence continues to suggest that until such a time that we go back to the Fiajo's commission's reports, the APRN, which did a lot of work, which citizens indicated that we needed a select, dedicated body to fight corruption, like the special prosecutor. And of recent, some of the committee that Professor HKP has led have proposed an ethics and anti-corruption office. And something again, let me bring in all the sweet proposals we have put in the NICAP. And NICAP here, I mean, what the president wants us to use to prosecute the agenda of corruption, where he has picked a specific individual to superintend over that in the person of Professor Dodu, who has led the process of developing the national ethics.
The better and popular name for that is Government WhatsApp Group.
Yes, the popular.
It doesn't matter that MPP people are on it. It is all of you have been bought by the government.
And perhaps let's clarify that again to say that the president brought together actors in the governance and anti-corruption space who he believed could put up proposals that would inure to the benefits or inure to the anti-corruption fight in Ghana. And over the past almost a year now, this group used 6 months to put together a document that is supposed to assist in prosecuting the agenda of anti-corruption. And some of the mega proposals include ethics to ensure that we are all working to promote good behavior, to promote conducts. And at the last meeting with the president himself, he reiterated the need to ensure that this is fast-tracked and implemented. So for us to see, and within that document, if I may say that we have beautiful plans that will help in ensuring, one of the proposals we made there was to put the office of the special prosecutor or write it into the constitution. Because of some of these mischievous endeavors we anticipated or we experienced during the last regime. So the conclusion was that we need a better regime around the fight against corruption. And one of them was also the composite law that brings together everything anti-corruption. And then ensuring that this office is written into the constitution to cure all the gaps and the mischief that is being perpetuated by those who are, let me say, who know the law and who are supposed to adjudicate it for the interest of the people of Ghana. It is sad, it is really unfortunate that we are coming to this discussion, distracting from what is happening. We were told that this government is going to fight corruption through oral. We had the Office of the Attorney General through its AG come to us to speak to some of the things it is currently doing when it comes to post-regime accountability. We have also seen the same AG initiate processes that have seen people go because he has the power to do so. But we believe without a doubt that the way the current AG's office is going, it is beginning to look like, at the time I said I didn't want this. And so my personal view and personal opinion is that because I didn't want it at the time, but then he came back to prefer some recommendations which you read, including a legislative instrument which has been done and signed. And for us in civil society, we believe without a doubt that the court erred. And we are going to also be working to ensure that that erring we understand, because the law is there for all of us. It's not for a certain group of people to interpret. We believe that the law as it is with its accompanying LI cured that lacuna which you all have been talking to. And I'm very happy to know that some of you here on this platform agree with us in civil society. And we know that in the coming days, we definitely will not let this lie, because there are others, other cases, the Supreme Court one, where the Attorney General has clearly indicated that he believes that the plaintiff is right and is joining him. So perhaps we in civil society and friends of civil society and all citizens who did the assessment on the office and indicated that until we have the alternative, this is the best way to go, would also take the initiative to see how we augment and change this situation without allowing the current status quo, which has been done through the courts, to remain same.
But the argument that is going on now, are you not able, including yourselves as civil society, to separate this case from the Attorney General? Because this case, in fact, was brought by one Peter Archibald Hyde, and it was against the OSP, and they were doing their case. The Attorney General had nothing to do with it. I've heard Dr. Kojo Pumpuni Asante, I've heard Edem Senanu of the Africa, the AU advisory on anti-corruption, all say that there are shenanigans that, we can't take away. There is a certain turf war between the AG and the OSP. But this is an individual who was doing his case even before these matters, where the AG brought his position in the Supreme Court. Yes, in the Supreme Court. And I've heard Kojo Pumpuni Asante and also Edem and your colleagues ask the question, what is the position of the government? The president. The president's position is known. they tried to scrap their office in Parliament. He said, no, I won't have it.
Samson, the president, that question I have also asked, what is the position of the president? Because we have had occasion to speak face to face with the president through the government WhatsApp groupings that we have. And so it's really is saddening the way things are currently unfolding. And we believe that the president needs to bring some clarity and finality to this, just like he did when the Parliament or the legislature decided to go through the route of repealing of the act through the majority leader and the chief whip. We believe that at this point, the president is the one who has appointed the Attorney General.
The president should have called. The president should have called Archibald Hyde.
Attorney General to order. That is one.
No, the president should have called Archibald Hyde, a private citizen who is being prosecuted by the special prosecutor, and say, don't file a suit challenging the OSP's powers. And then the president should call the judge and tell the judge, don't give him a decision. Is that what you're saying?
I'm saying that is not the case. That is not the case at all. The president cannot tell the individual not to do so, but the president can
admit that the systems are working. The system is working.
No, please, Samson, let me come. Let me finish or let me land. The president's views are those being espoused by his Attorney General. And remember, there is an outstanding case for interpretation in the Supreme Court, which the Attorney General has decided to go with the plaintiff on. And that says a lot. It speaks volumes. That is why we need the president to speak. Again, after the ruling, the glee and the haste with which the Attorney General came out to express himself is quite worrying. And to go to the extent of saying they are putting in place steps to ensure that they take over cases means there is intent, and this intent has been expressed.
You don't want the Attorney General to obey. You don't want the Attorney General to obey the order of the courts.
Or obeying the order of the courts when people are talking about appeals. The office, we know, for instance, that the office of the special prosecutor has indicated quite clearly that they do not agree with the ruling. And when we do not agree, we take steps. And they've indicated same. So what is the haste? Why are we?
But we don't. We don't even know if there are. We don't even know if there's an appeal yet. But even if there's an appeal, the pendency of the appeal or the filing of the appeal does not stop the judgment. The judgment is still in effect.
Samson, we don't discount that. But the haste and the glee with which this is happening and the commentary from the office.
What is the haste? What is the haste? When they say we want to take over and then still say in the same breath that they spoke to Justice Sremsai, spoke to Dr. Justice Sremsai, spoke to Joy yesterday and said, we are ready to give the OSP the authorization if they ask for it.
Samson, which authorization? There is no need for authorization for us. We believe that the LI cures that because the former Attorney General, as it has been espoused here over and over again today, signed onto that LI and gave the Office of the Special Prosecutor authorization to carry on with investigating corruption and prosecuting same.
Okay, thank you very much, Mary. And somehow you and Kojo have been lucky because whilst you are the last to speak, you have had more time than the first guys who spoke. You've all spoken like 20 minutes. Let me go to Kenanku.
I'm making an intervention.
Right. Kenanku says, thank you. Lawyer Kenanku says that statutes are construed while constitutions are interpreted. On this occasion, Kofi Bentel is right. Respecting how a statute is construed. The reference to the memo, the memorandum to the bill, to see the mischief the provision seeks to cure, that is also spot on. This is a basic principle of construction of statutes. The Constitution, we are told, is a living document that cannot be interpreted slavishly. Is that not the reason why the Supreme Court interpreted a simple word, shall, to mean may? This was to achieve a purpose. Or I am not thinking properly as a lawyer. All right, thank you for that. Because he says I should tell Bafo about that because you are harping on the shall, you know that the Supreme Court has said in a certain circumstance, shall was may. Papa Bisu in Sphincters, Accra says, in the first place, the formation of the Office of the Special Prosecutor was in a rush because they didn't take Article 88 serious, really. That's listening to lawyer Ayikwe-Otu, former Attorney General and a member of the MPP. Hence, that office was naturally bound to face problems in the future relative to some of their functions because it needed to take some orders from the AG. Yakubu Ibn Chambers in Wale Wale says, sometimes I wonder in a crescendo of disbelief as to why our policy framers would go through lengthy articulation of thoughts to create replication of duties among state institutions. Under no circumstances should the office of the AG attempt to usurp the powers of the OSP based on the wisdom of provisions of the Constitution. There is this popular saying in Chi that the Attorney General must steer clear interfering with the OSP and concentrate on the unfinished works on his desk. Frank Anderson Jr. Says, from what you have read this morning, the debate over the years and the submissions made by your panel, the safest and most sustainable path to ensuring the independent functioning of the OSP would have been through a constitutional amendment, particularly in an environment as politically polarized as ours. We shouldn't be here otherwise. While the Office of the Special Prosecutor is undoubtedly relevant, the current approach appears not to meet the test of time. That's why people are asking. This government set up a Constitution Review Commission. The commission has brought up recommendations. They say write the OSP into the law, even though giving it a different name. So why not pursue the implementation of that rather than join in the Supreme Court and say it doesn't have a power, it should be sort of scrapped. Opokwe J, also a lawyer, says the Attorney General cannot just give a fiat to OSP to continue pending cases. If the OSP has no power to initiate cases, then cases it has started are null and the accused must be discharged. And if the AG wants to prosecute, it must start afresh. Even if OSP is giving the fiat, it cannot continue pending cases. Pending cases, it initiated illegally. All right, it initiated illegally. Fred Simpson Gura, also a lawyer, says, we fail to see why we all advocated for the Office of the Special Prosecutor. We defeat the purpose of the whole act or office if the SP must always go to, if the SP must always go for authorization. In any case, why would the AG wait for the SP to apply before granting the said authorization? Well, we are really serious in our corruption fight. Many of your messages here, and I'm trying to make sure that I capture as many of them as well. Mancha Bruce, the second, Takrade says, I'm surprised that the NDC government, which benefited from the outcomes of the work of the Office of Special Prosecutor whilst in opposition, is now taking precipitous steps to dismantle the said office. Reset indeed, amazing convictions. You forget that in the MPP regime, there were also steps to dismantle the office. Don't forget these things, okay? Okay. Please, that's not an argument to have. Excellence reign. Excellence reign.
And the recent petition.
Excellence reign. Please, the OSP suffered a lot within your regime.
And in this regime
not by
also. Senior members of our party.
In this regime also.
That distinction should be clear.
In this regime also. Gentlemen.
The petition was from Martin Amidu.
Gentlemen, there were petitions from Ken Koranche to the Supreme Court. Ken Koranche is a senior member of the NP. Has stood for elections how many times?
Not of the same pedigree as the majority two chief whip. And the extent to which, look, you are referring to a petition.
Thank you.
Parliamentary processes initiated by the current government to abolish the OSP.
That's an interruption. I'm reading those messages. Okay.
It's deliberate.
And
you made a good point.
And therefore, to be frank, so Kofi, to be frank with you,
yes,
I've gotten tired of this argument about which is a sound law. I like to keep it to myself, so I moderate the argument as they go.
But we all know they are the same.
See, even in this regime,
we know they are the same.
Will you be surprised to hear, that you know that the Germans are helping the OSP a great deal. They are the ones helping them to set up the forensic laboratory. Will you be surprised to hear that the equipment for the laboratory are being shipped to this country, and they wrote to the finance ministry asking for exemption, which is normal for all institutions, and they have been denied. You won't get the exemption. Find your own money to pay for it. So there are a lot of things going on that people read meanings into. They say recently the court sort of the attack. I don't know how to desegregate them properly from government is not involved and all. I tried and it can work. But they say they are pursuing certain cases that people are not pleased with. They are pursuing cases where even national security is involved, in seeking to stop them from pursuing those cases.
But I mean, if government can go, if senior members of the government can go as far as to seek the abolition of the OSP merely because of Mr. Martin Pebu.
No.
Then what else can happen?
Why do you
I mean, he came
after
but it's very fundamental.
Martin
is very.
You may have issues with Martin.
Samson, Martin is my friend.
It's Martin and NDC,
Martin is my friend.
He's not a member.
But we can never divorce the issues. You see, there's a chronology. It was post the arrest of Martin Pebu that the moves were made in Parliament.
That's a
no.
Thank you.
It doesn't mean
excellence reign.
No, but
I hear you. Let me read the message.
There's a nexus.
Thank you.
But it's not causing.
Excellence reign.
No, it's not causing.
Says Ghanaians are expecting so much from the Attorney General, and up till now, nothing to show for the oral cases. You see, there's the same thing we have done to the OSP. When they are prosecuting cases, we want them like. No. It doesn't happen that way. So the oral cases, please, let's stop saying the oral is crashed and all of that, because it is patient. You don't do them in a rush. Thank you.
You are trying to stop.
The young magician.
Forget the young conferences that the Attorney General went on to say that.
You are being disruptive.
Okay, I apologize.
The young magician.
I apologize.
There is no doubt we had issues with the creation of the OSP. If we really want to fight corruption, I believe this is not the route to use to disarm the OSP. The government is trying all means to turn the office into an online shopping store. The trajectory is glaring. Okay, once again, I don't know what to say because, people are entitled to their, what they say. I can't, as it were, muzzle what you say. Please, this case was a certain Peter Archibald Hyde, who is being prosecuted, who went to the court. And it's a fight between him and the OSP, not the Attorney General. Akilu Fantiakwa Begro says, I want to ask, please, has the Office of the Special Prosecutor prosecuted some criminal actors in Ghana so far? Yes, it has. And it has many of them on trial, and 7 or 8 of them convicted. Sergio says, we are going to use another month or 2 to discuss OSP AG matter. Our politicians are very smart. By the time we finish talking, most corrupted ones would have bolted with their goods. Homer says, what at all does government fear that they simply want to get rid of the OSP? Baba Chairman in Tamale says the OSP brought this needless cacophony upon himself. Okay, so you mean the SP, not the OSP. The SP brought this needless cacophony upon himself and the office when he was swollen and went after Martin Pebu, the poster boy of the NDC. From where I sit and the Martin Pebu I know, it's not correct to say he's the poster boy of the NDC. All right. So this is where we take a quick break and return to the arrest of Abronye. This is the second arrest. And then there is Baba Amando, who's also been arrested. I'm sure many of you know what they have been arrested for. How do we draw the line? Where do we draw the line? Free speech and abuse of that right.
My name is Akyeman-Rawlings, and Alphabet City says I should tell you about the Easter promo. So this very Easter, Alphabet City is giving out 11% discount on the full price of this beautiful semi-detached 4-bedroom. And they are saying that if you are buying within this month of Easter, because of the grace, they are going to give you free solar panels. And I repeat, free solar panels. The Easter grace is available for all. Secure your home with only 20% deposit of the full price of this beautiful home, and it's going to be yours forever. So call 0240-111-119. Alphabet City, the ABC of home sweet home.
Number 1 from here, 2 and 3 from here, 5 and 6 from here. For now. Yay. Now I have the number 7, 8, and the number 9.
You need number 10.
Please, I can't eat anymore.
I mean, number 10, liver salt.
The effective liver salt for the relief of stomach upset, heartburn, hyperacidity, and indigestion.
Would you like to try number 11?
What?
Number 10 liver salt. Refreshing relief fast. Manufactured and distributed by Ernest Chemists Limited. This advert is FDA approved.
Welcome to Malcolm, where shopping is a musical experience for all generations. Granny's, let's roll it back.
Malcolm got now we did for you. Malcolm's got it all for me. Life made so easy, easy. Lemon squeezy, shopping made easy. Sometimes money day, sometimes some way out of pocket. Malcolm's easy. The price is right.
The price is right.
The price is nice.
The price is nice.
Fresh with the vibes, unbeatable. Do the price they fly.
Do the price they fly.
Your number one stop shop, number 1. Your number one stop shop, Malcolm. Malcolm got now we did for you. Malcolm's got it all for me and you.
No matter the generation you belong to, Malcolm is where Ghana shops.
Bring back home the experience.
Bring home the experience.
In my line of work, a confident smile is everything. Kale Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kale Charcoal Toothpaste. Kale Charcoal Toothpaste. You're on a Kessie and in a kit one.
mayo kendini ehu behia se metwa sapapade to ama me manfo Kel Charcoal's natural ingredients eno ene bome se ho ban e ma ne sren ne sanso mama hotoso e wo bedwam
Kel Charcoal toothpaste. Choose Kel Charcoal toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kel, happy smile. This advert is FDA approved.
In Ghana, our gold is more than a resource. It's our pride. And at Gold Ball Jewelry, we celebrate that pride every day with craftsmanship that reflects who we are as Ghanaians. Introducing the Gold Ball Jewelry Gold Tablet. Pure, certified, proudly Ghanaian gold. The best part, when you buy a Gold Ball Jewelry tablet, you own it. You keep your gold with you, not with us. It's more than a jewelry. It's a smart investment for every Ghanaian who wants to secure their future. Gold Ball Jewelry Gold Tablet. Own your gold. Own your future.
Did you know that laser can be used to help diagnose and treat your glaucoma?
You can have modern cataract surgery like those done in Europe and America right here at the St. Thomas Eye Hospital. You can have modern phaco cataract surgery, retina detachment surgery, macular hole, and all kinds of laser surgeries done right here in Ghana. TMC or SUSU. But it's just to tell you, St. Thomas Eye Hospital provides total eye care for you and your family in a serene environment with world-class equipment.
Visit St. Thomas Eye Hospital Surgical Center at Mathaheko or their Oxford Street branch.
I say, anywhere way, Yentong. St. Thomas Eye Hospital, providing excellence in eye care.
You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. Yes, we mean it when we say most authoritative. And thank you for all of you who are saying this being good, balanced education that you have received this morning. Yes, we're deliberate to allow our guests to flow and to use the law to explain it in the manner that is worthy. This show is brought to you by Bank of Africa, as strong as a group and close as a partner. MTN, everywhere you go. Ashesi University, educating ethical on entrepreneur leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial star 165 hash on MTN to join My Way today. Syntex Tanks, it's strong. It's tough, and Safari Valley Eco Park, bringing you closer to nature. Now, let's go to the court. And as you know, still in the court really, the NPP has been crying foul over the arrest of Abronye. This is a second arrest within a very short space of time over his commentary. Some say vitriol is not the same as speech that ought to be punished. And Baba Amando, for the first time, also facing the speech offenses. So we are asking, free speech or reckless speech? Where do we draw the line? Let's check a few of the things that happened around the court, particularly on the first day when bail was denied to Baba Amando.
Yeah, I did. I was with Afenyo and Co.
I've executed a bail bond for Chairman Abronye and Baba Amandu, the two of them. They've released them. They've set conditions for reporting, and we are thankful to them. We only want to draw the attention of Ghana Police and the government to appreciate the fact that in a democracy, there must be some level of tolerance. They've raised some concerns regarding some issues that have come to their attention. I'm sure the legal counsel would take those matters up with our colleagues. But I would also want to urge them to be tolerant, and let's try and manage some of these things without creating a whole media outrage or showing somebody where the power lies. But let me again thank them, the IGP and his CID boss, for accommodating us, listening to us, looking at the time. They should be closed and gone, but they've cooperated with us. Chairman Abronye was sent into custody. They have brought him back, and then bail has been granted.
Social media to identify people who criticize the government, and in midnight, early hours, will go and arrest these people. If they know how angry Ghanaians are with the disappointment that they have about this government, the promises that they made to Ghanaians when they were in opposition, the promises to create jobs for good people of Ghana, the promises to pass the LGBTQ bill within 3 months, the promises to increase the price of cocoa.
They did not even put any application. Yet, Justice Joseph Quison, you could see that he had a predetermined mind. He had a political mind, and unjustifiably remanded Baba Amandu to reappear on the 20th under the guise of interfering police investigation. This is even more absurd.
Right. Yes, so the first sound you heard of Afenyo-Akin, or Sahin Afenyo-Akin, the minority leader, was after the police had granted them what is known as self-inquiry bail, police inquiry bail. And he was excited and thanking them for granting them bail, but they had to appear in court. And when they appeared, then the developments occurred. Then subsequently, you had the comments that, followed. Yes, I don't want to start with Bafo.
So I can give you proper background.
I don't want to start with Bafo.
Because I've been an actor.
Yes.
So you take the last one. You were in court. So
when I supply with your information,
okay, go ahead.
You can now do all the analysis.
Okay. And we have to be very brief with this.
So I will do I'll brief. Something I think that some of your viewers have seen a video go around. And we discussed it from the outset. And indeed, when you watch the video, I said, this is the first time I'm doing this. And as I said earlier on, it's because of things we've bottled up for far too long. There are two issues to this: the arrest itself and events in court. Take a case like Baba Amandu. He said all he did were memes, which have become part of our political communication, particularly in the era of social media, and the tools available to communicate without saying much. I mean, if you arrest him for draping people in LGBTQ colors, then you'll be arresting somebody for accusing the government of its failure to sign anti-LGBT bill, for not being active in its advancement, in the advancement of the anti-LGBTQ. And so there's always a fine line between, free speech and, things that may inhibit free speech. And so you need to be very careful with your approach. The Baba Amando was asked to report to the police station in Sunyani. He went there voluntarily in the company of his lawyer, the former Deputy Attorney General, Tuya Yeboah. They get there, and he's told that he's required in Accra. So he is conveyed from Sunyani to Accra in a handcuff the whole time. Even to use the washroom, he was in a handcuff. To eat, he was in a handcuff. For 8 hours, he was transported in a handcuff because of memes, pictures that he has draped in the president's picture, the president's picture, Felix Ofosu-Kwakye's picture. And
you're wondering what their intervention is.
I know. Don't worry.
When you said he was eating in handcuffs.
Yes, I'm telling you. I am telling you. This is what the gentleman has told me. This is what my client has told me.
Baba for eating handcuffs.
Oh, my brother. Well, that tells you what he has gone through.
All right.
That tells you what he went through. Now he gets to Accra. Let me commend the police. The Director General of the CID, she was fantastic.
COP Lydia.
Yako was very, very, very fantastic. The investigator, Obed, he was also solid. So we went there, led by the minority leader, Osahene Afenyo-Markins. We got there, we spoke to them, and were able to secure bail for them. Amando was told to report the next morning at 10 o'clock. He got there at 8 o'clock. The police never revoked the bail. The police only informed him that they have to come to court. And so he came with the police to court. When we got to court, and then the police, all the necessary process were done. The charges were read to him. They took his plea. The prosecutor then made his submission as to what the brief facts are. And it was done. Then, Osahene, who led the defense team, made an application for bail, which is natural. When he made the application for bail, I have the record of proceedings from the circuit court here. This is the response the prosecution gave at page 5 of the record of proceedings. My Lord, it is tried learning that grant of bail is subject to judicial discretion. The principle was reaffirmed in the Supreme Court case of the Republic versus the Registrar of High Court, ex parte and Attorney General, GLR 407. His Lordship Charles Crabb, JSC, reasoned that the grant of bail was an exercise of discretionary power, and the main consideration was the likelihood of the person concerned failing to appear for further proceedings. My Lord, even though we have maintained our position that investigations are still ongoing, we leave the determination of bail entirely in the hands of this honorable court. We so submit. So he never said we are opposed to bail.
It's not an opposition.
He never said we are requesting for his remand.
You are interpreting. That
we are not. It is not opposition. We are
interpreting it.
Something we don't have to interpret this.
Okay.
We don't have to interpret this.
Said we leave it entirely in
yes, because
even though investigations are still ongoing.
Wait, I'm coming. Something. Bail is a discretion of the court. If you're opposed to it, you say it. My Lord, we are opposed to this application. That is the practice. In fact, if the police wants to remand you, they will say so, that, my Lord, investigations are ongoing. We require a remand of this accused person to enable us complete investigations. The prosecutor never demanded remand. He never expressly opposed bail. Now, this is where the problem is. Even after the prosecution has done this, some say the judge goes on like, are you sure you don't need him for investigations? And the prosecution says, the investigations at this stage is in the hands of forensic experts. Because it's a communication offense. It's an electronic communication offense. And the investigations are being done by forensic experts. Some say, after the investigator had said this, the judge then goes ahead to say, how long do you need to complete your investigations? The investigator says 1 to 2 weeks. Then the judge asks him, are you sure you don't need him? The investigator repeats that it is a forensic investigation, and so it's in the hands of forensic experts. That notwithstanding, look at the judge's ruling. Look at the judge's ruling. You could tell that it was a preconceived, prejudiced ruling. The court has listened to both counsel for the accused and that of the prosecution. Counsel for the accused prayed the court for bail for the accused person. Prosecution in its response intimated to the court. Prosecution in its response intimated to the court that investigations are still ongoing, and for that matter, the accused will be needed. Where did the prosecution say so? Where did the prosecution say so? The court is of the view that each party should be accorded opportunity to present its case. Hence, 1 week will be given to prosecution to conclude their investigation. Accordingly, the bail application for the accused is declined. My brother, where did the prosecution say so? So even after he had not gotten the responses he wanted from the prosecution,
mix it up
to enable him or ground his preconceived ruling, he proceeds to make it up in his ruling for the prosecution. The judge was not just a judge, but he was also a prosecutor in the matter. He was a prosecutor in the matter. My brother, this is where the anger was from. This is where the anger was from. Because some said the offense it's in itself is even a misdemeanor. And let me tell you something sad that also happened in the court. The prosecution, the charge sheet they brought, the brief fact, they have stated in there that after the investigations, the accused was charged. Supposing that the investigations were complete. And so when the prosecution stood up, and then he said the investigations were not complete, Honorable Afenyo-Markin stood up and told the judge that when you look at the charge sheet, the prosecution has stated that the investigations were complete because they have stated that after the investigations. Do you know what the judge said? Prosecutor, your attention has been drawn. Your attention has been drawn to the inconsistencies in what you are saying and the charge sheet. What do you want to do? Then the prosecutor says, my lord, I want to amend the charge sheet to say that investigations were not complete. This is where the anger is from. In any event, some said, I have said time without number that our court is supposed to stand, firstly, if you look at the political actors, it's supposed to stand in between us.
What has the NDC got to do with it?
The judge was presiding over a matter involving members of the NDC. The president is a president of the ruling party, from the ruling party, NDC. Sam George, who was also dragged, is NDC. Felix Ofosu-Kwakye is NDC. Are you telling me that if it was an ordinary Joe, that would have happened? That wouldn't have happened. You see, Samson, when you get yourself into the arena of
conflict. That is why you say the judge, the only difference between him and an NDC person is that he was wearing a wig and gown and a
If he walks like a duck, quacks like a duck, then it's a duck. What will motivate the judge other than in a case involving NDC actors
Can't a judge?
No, that is also.
Can't a judge exercise their minds, even when they are not affiliated to any party, to give a decision that may coincide in supporting a party, a political party?
So when you leave room, when you conduct yourself in a manner, right, which raises speculation. This is one of the speculation.
And the conduct that you dislike is it as a practitioner? Is it your understanding? And you know this. Is it the case that because prosecution has not said we want them in custody, the judge cannot say it differently?
Sam said, first and foremost.
Because the courts,
you have asked me a question.
Because the courts, as it is, I've been asking that question too about the case of the OSP in the Supreme Court, where we project a thinking that suggests that if the OSP doesn't go, because the plaintiff has said OSP is wrong, doesn't have authority, AG has said, AG has said OSP doesn't have authority, the judges will take that hook, line, and sinker. When in fact, the judges, sometimes a plaintiff comes, brings their case, a defendant doesn't show up, but they will still make sure you go through the process, and you may lose, even in the absence of a defense.
You are comparing apples with oranges. Wait. First and foremost, under the Constitution of Ghana, bail is presumed. Bail is presumed. Secondly, it is for the reason that bail is presumed that Section 96 is also provided for. That in the circumstance where you want to deny a person bail, these are the basis on which you deny the person bail. Right? None of them, if you look at what has prevailed here.
So the discretion ought to be exercised judiciously.
But judicially. But if you look at what has happened, the judge decided not to even exercise the discretion judicially. The judge was himself a prosecutor in the matter. He was himself a prosecutor to the extent that even when he was not getting the information he needed from the prosecutor, he chose to make it up.
Many times you have gone to a court where prosecutors are rather tardy, and the judges are the ones that probe them to do something.
Do you say what the prosecution hasn't said?
No.
Do you say when the prosecution hasn't said that we need this person, does a judge write it down that we need, the prosecution has said he needs him?
You know the line of questions I'm asking you now?
Yes.
You know what some MP people are saying?
Yeah, that you're NDC. No, you are not NDC. Anybody, let me say, I've known you.
We don't be the same party.
Samson, I have known you from 2010 when you were with Gezi, when you were with Alzwenis.
Yeah.
We have had great conversations, political conversations. That's what we used to eat and talk. And I know you. But I'm saying that, Samson, from the facts, if it was not Felix Ofo-Skwachi involved, if it was not President Mahama involved, if it was not Sam George involved, senior members of the NDC and the ruling party, will a judge, right, conduct himself in the manner which he conducted for a misdemeanor?
How do you know? How do you know?
Yeah. Well,
a good question.
It's a question I'm asking. You see, when you do this,
you are not only asking. You have concluded.
Yes, but I'm saying that when you do this, you leave room for speculation.
All right.
And I am saying that the propensity, the probability that I'm going to come to the conclusion which I did are the facts that have made me, the facts that I've put out. That look, everything points to the fact that the judge was wrong. That you even make up stories for the prosecution. Things the prosecution hasn't said, you put them down. Why would you do that? Yeah. Why would you go to that extent for the prosecution?
Right. So the last question to you is, the things they did, you speak about dripping the president and the others, or these people in LGBT colors. Rainbow colors. Do you approve of it? Abronya, what was his offense? Say that to, let's get to hear that from you, your perspective. What is Abronya's offense?
Abronya is said to have said a judge is more political. Abronya is said to have said so. Samson.
You think he just said more political?
Samson, I do not. I may not approve of it. I think that there should be sanity within our political space. we should begin to discuss ideas. Politics is about ideas. And because the space is being taken over by insults, ideas is dying. We are killing ideas. What we are doing this morning, we are discussing ideas. Today, when you suggest an idea, everybody is insulting you. I remember there's something I've been reiterating recently. When Mame Akufo-Addo Dankwa said, it's very difficult to prosecute a white-collar crime. People, were insulting her. But it's the truth.
Correct.
This morning I was telling you that if somebody secures an approval from PPA for a contract which is overpriced, heavily overpriced, it becomes difficult for you to prosecute that person. Because the person will go to court and waive PPA's approval. And so, but if we had not insulted Mame Akufo-Addo Dankwa at the time, and we had all subjected what she said to proper discussion, perhaps our state institutions would have been better with these things. And so, I agree, it might not be right. We must condemn all forms of insults. The insults, the condemnation might not be those that are happening today, but those that are even contracted outside of the country to insult chiefs, to insult everybody, is killing very genuine discourse that would ensure growth and development.
Right.
Yeah, Samson. You see, I will not condone with things that happen. Free speech is not absolute. It's not absolute. It comes with responsibilities.
No.
And in democracy, we encourage people to speak, participatory democracy. But that does not mean insults. That does not mean gestures, right? You see, bail, when it comes to the court, bail is discretionary and it's within the bosom of the judge.
But the discretion must be judicial.
It must be judicial. But there are things that something, it is not taught in the classroom. It's not written. I'll give you a classical case. I did a bail. I was going to do the bail. The gentleman was in the box. When the judge was asking him questions, look, it was just like a misdemeanor. And he was laughing. He would smile. He was laughing at the judge. After arguing, the judge said, oh, I look funny, eh? Going.
Mm-hmm.
He may not have exercised it judicially, but your demeanor, what you do when you are in court, will determine how the judge, they are also human beings, right?
Not just that they are human beings. The jurisprudence.
The jurisprudence.
Is that demeanor is taken into consideration.
It's taken into consideration.
When a witness is giving a testimony. Except that you shouldn't allow the demeanor to prejudice what you have to do.
Yes. Right. And
that's why if people are, disheveled, you want them to clean up.
Yes.
If they are wearing tattered stuff, you want them to, if they have a hair that is not properly, you want to keep them nicely. Sometimes you say wear a suit, get a tie, and make yourself presentable, because all of that influences.
So if you get into the box and you think you are more important or superior to the judge, right? Yes, we all make mistakes, right? But you see, because it's discretionary remedy, you have to court the favor of the court. You carry the favor of the court because you want favor from the court, because the discretion that has been, he can exercise it rightly or exercise it wrongly. But at the end of the day, you would suffer the indignities before it is corrected.
I was taught in chambers very early on that in this country, you, the lawyers, you are part of the problem.
Exactly.
That's everything. You really want to see the judge as a lord. And the Lord is not a reference to us in the Lord. It's reference to the king or the queen.
Yes.
To whom authority belongs for the judiciary to exercise. That's why you call them my lords.
My lords.
But sometimes you, the lawyers, because you are looking for a favor.
Of course.
The judges will say things that are wrong. You can't even point it out to them. even if you have to point it out, you are timid in the way you do it. And you encourage them. Very early in my practice, my senior taught me in chambers.
Yeah, but something.
We encourage some of these.
No, yes, we encourage, but the thing is that, you see, there is a way to communicate to the judge and say, my lord, I've spoken to the judge, I said, my lord, I think inadvertently you've not read this case. You've not read this law.
And you have to find a way to say it so politely because you are afraid of hurting them. When the judge is wrong, you can't tell them to their face you're wrong. Meanwhile, that's not an insult.
No, it's not an insult. But at the end of the day, especially when it comes to criminal matters, the issue at stake is liberty.
Right.
Somebody's liberty.
Probably.
Right? So if liberty and right, you need to have a balancing act. You know, so the judge, in as much as the case has been put before him, it is his discretion. And if he decides to exercise it, and it is wrong, right? We can only criticize him until it is done. But you see, issues that had been brought, if you look at the ruling and the rest, is that the judge was seeing some few things, and my information is that this man has been a police investigator all through his years until he joined the bench. So he might have been seeing some things that the prosecutor maybe was not seeing based on his profession as a police officer.
Or ordinarily, he's an activist judge. The judge we just spoke about a while ago, Justice Nyandu. That judge is an activist. He talks.
Or something else.
Yeah. So, and you see, in what has developed, a culture developing within our culture, within the politics, is that people think that when they are abrasive, when they speak within misguided comments are being made, that is a claim to their fame, because they know at the end of the day they'll be arrested and people. Look, once I used to do in opposition, some of the cases, one police officer called me, a senior officer sometimes said, Adahudu, you and some of your colleagues, don't you think you are the problem?
Mm-hmm.
And I sat down and I said, how? And he said, because they know these lawyers are there for the party. Anybody could go and spew any negative, insult anybody. By the time they bring them, we run to the police station and say, give him bail. We start to make. It was then I started to tell the people that, look, you know what? If you go and do anything reckless, me, Kojoga and Daudu, I won't come. No, when I started and telling some of them they stopped. When they do and they call, I said, what did you do? Huh? What did you say? I said, go and face it. Most of them stopped because they realized that they don't have that backbone. So at the end of the day, it is some of us, the politicians, also that causes this.
So you think holding a press conference as a party and deprecating the judges or the police over these matters encourages the party?
Encourages them. Because we as politicians think that that will energize the base. So once it is done, then everybody follows in line, solidarity, and that is what edges people. I always ask questions. Why is it that maybe Samia Uku, my learned friend here, they've never had problems in anything or any of the grassroots. But this is the second or third time Abronye is being, because he thinks that when he speaks, he says anything is a claim to fame for him. And he knows that when he gets there, people would come, or everybody who matters will come. I think we need to learn and let the people also know that, yes, I'm not saying that they may not be misguided or unguided statements because we make mistakes as human beings. But we need to learn the ethics. And it also tells you about the character formation, how you were brought up. There are some things I will never and I won't be able to say. But for other people, they can say it and insult others. In my life, whilst even in opposition, I have never insulted any person, any opposition. They'll say, oh, criticizing, you should be acidic. You should be acidic, say this. I said, no, that is not my training. Because, you know, so the issue is that Yes, the judge, listening to all, might not have done the right thing, but at the end of the day, let's look at what happens and also advise our followers that, look,
these repressive legislations, I'm sorry, I'm coming to Kofi Bento now. These repressive laws that are still sitting in our statute books, Section 207, Section 208, and then the Electronics Communications Act, 67, or which one of them? I always know them. Why am I forgetting? Do you want them off our statute books?
Yes, they should go off our statute books. They limit our development.
Do you know the problem that may come?
No.
If we take them off?
No, it's not a problem. And I'm very careful what I'm going to say because it's not popular.
What's wrong with a law that says any person who in a public place or at any public meeting uses threatening, abusive, or insulting words or behavior with intent to provoke a breach of the peace, or whereby a breach of the peace is likely to be occasioned, shall be guilty of a misdemeanor. Then 208 says, any person who publishes or reproduces any statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, is guilty of a misdemeanor. All they are talking about is don't churn out falsehood.
That's not what
Do we want to promote a society where people deal with falsehood?
That's not what they're talking about. And if you read the law carefully, they use important words. You are in a public place. You are saying things which are threatening. Okay? Fire. Hey, I'll kill you. This, threatening. You are putting people in apprehension of their safety. And you have intent to disturb the peace. There's so many words that are important. All right? So look, anybody with a good grasp of jurisprudence and who understands this democracy thing and the principles underlying it and how good societies are formed, etc., knows that there are certain things that come with all good society. One of them is freedom of speech, freedom of thought, freedom of association. That does not mean, people will not do wrong things, but it's a balancing act. And I'm being careful with what I'm saying, even though I know still I will be.
The things they say and get into trouble.
Let me finish, I beg you.
And the things they do and get into trouble, will you ever do them? Will you ever approve of your child or somebody associated with you to do?
I'm trying to articulate it because they are very dangerous things I'm going to say. You see, one, we are moralizing. My brother, that would moralize it. If you go and do something, that's a different thing when it comes to jurisprudence that we all studied. And I keep saying that, look, these things that have come down to this are democracy. 4,000 years, Socrates, Plato, Aristotle, and it may not be ordinarily, easy to explain. But Noam Chomsky said something. He said that free speech is a protection to the people you disagree with, which allows them to say things you don't like and which you find offensive. That is what it's about. Okay? Now, me, I have been in the public eye since 1991. I don't insult people. If you tell me any of my children has gone to insult anybody, I'll tell you it's not true. If you say my wife has gone to I am raised differently. I do things differently. But I will defend the right of other people to do things I disagree with, not because I like it, not because it's nice. In Ghanaian society, those things, we frown on them totally. But in doing that, we take a lot of things out. So our laws, and when people say free speech is not absolute, it is absolute. Free speech is absolute. The only limits concern the rights of others. So when somebody goes out and says things you find disagreeable, insults things, even in court, the law is not shy of certain types of language. Okay? But if the person feels aggrieved, they have a right to sue you for defamation, you can speak and the speech will be assault. Okay? They have a right to sue you. But when you have a situation where people you find disagreeable, like Abronye, who I don't agree with, okay, on a public platform say things which you find disagreeable, to the extent that they are not in public and they are not issuing threats and they don't have an intent to disturb and whatever, a lot of these things are insults or things that we find disagreeable, etc. We should be careful not to use the hand of the state.
They are doing it in the public.
Yes, they are doing it in the public. They don't. If you look at what they've done against the laws that we have, okay. And by the way, we've said that these laws constitute criminal libel in another form. That's why I'm talking jurisprudence. If you look at them clearly, this thing about publication of false news, you have a right to publish false news. And if somebody finds it offensive, let them go and say, what
if it's against the state?
Again, you see,
the state doesn't have a right to sue in defamation.
No.
The state
entities, they don't have a right to sue in defamation.
Because the state doesn't have a business in defamation.
So if we should allow you to shout fire and get people to panic.
No.
And then we all...
Shouting fire in a public place will qualify for all these things. But when you go and say certain things that the state finds disagreeable, you are the state. You are our employee. Okay? The state does not have a business taking umbrage at the speech of citizens. Okay? If you say something against a state institutions, many of them can sue and be sued. All right? So look, those who...
No, but the only remedy you are talking about that they can sue is for defamation. But they can't sue for defamation too. The law doesn't allow that.
It's not defamation alone.
But there's no other option for them.
You see, there's a reason why the state is limited in its recourse when it comes to people attacking it and being scurrilous about it. All right, there's a reason why. Because you have to expand those spaces. And I'm not saying because it's nice. But that's why I quoted Noam Chomsky that says that the purpose of free speech, okay, is that it is for people you disagree with, who say things you don't like and you find offensive. But that's the point. If you can't handle public office, don't go there. All right? So look, the state must have a wide latitude. And I'm not saying this because I agree with Abronio or whatever it is. And I agree with the sentiments that have been raised about demeanor. A lot of these things, the kind of reaction that the state, visits on them is because they are disagreeable people, and generally speaking, everybody agrees that this guy there, I don't want to use the word, he talks by heart.
Should we continue this way as the parties do? And normally it's the parties. Victor talking now, I can assure you that if it were NDC, he would do the same. Yeah. Okay, the thing that he thinks Nana is not doing right, he would have been at the same place. Yeah. I remember the Muntie.
Muntie 3.
Yes, they were.
They were defending.
We were on this platform many times.
So you see,
my question is: should the parties continue this way?
No.
That once a police officer acts, they say it is the president or it is the state. Once a judge acts, they say it's the president or it's the state.
The parties should stop it. In fact, that is where the problem is. Some of these people, they do it because they are doing it within, that umbrella, and they believe they'll be protected, and usually they are. Look, we sat in this country, there were times when there are things that you will say that the party won't necessarily support you. That is the moralizing part.
We have that.
Yeah, now it's gone. We are shifting, okay? My worry, however, my issue really is with the use of the law, okay, to stamp on some of these things, and I think it is not necessary. Something that is being missed, and I think it's important to that. Okay, please, see, the police have raw power, and they are more prone to abuse that power. And the judges are the ones who have to stand between them and us to do justice. So it is very, 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 very sad hearing what my brother Bafo is saying about the attitude of the judge, okay, who instead of, adjudicating, sounds like he's playing into the prosecution, ends up granting things that have not been requested.
Okay.
It's sad that we do these things. Look, free speech must be allowed. We must expand that space. Now, let the person...
You miss your friend, Justice Anthony Eboa.
Oh, I miss him so
Okay, let's go to Mariana. Hello, Mary.
Oh, okay, Anthony.
Yeah, Justice Anthony Eboa.
When you read his reasoning...
People were suing... the clients I deal with, journalists and the media. They were suing them for defamation and things. And I will go to the Constitution and talk about the right of speech. And he will uphold it. Yes, Mary.
Right and reasoning.
Oh, yes, it was a good
man.
Hello, Mary.
Good people die.
Hello, Mary. Are you with us?
Yes, I'm here.
Right.
Can you hear me?
Right. Yes. What do you say about this thing, these laws? Are they not necessary in a state?
Something I believe without a doubt that laws are important to regulate human behavior. As much as we are all, we would want to do things and do them the way we want. And so that's why we have the laws to regulate such behaviors. I want to also say that in this instance, and this is not the first time, we believe that citizens have rights, but then those rights must be expressed, remembering that we also have responsibilities. And so whatever I say, meaning it to affect another person, means I need to be saying it from a place of view of either evidence or what I have in hand, which I believe to be so. We need to also remember that we must be responsible in our public communication, particularly in these days where artificial intelligence is popular and people can take my head and put it on yours and it will reflect something else. We need to also be able to support the institutions of states which are working to ensure that they regulate our behaviors. And in this instance, I want to say that as the other panelists have said, they said the institutions of states, particularly with law enforcement, they behaved very creditably. He mentioned the CID boss, and he mentioned the IGP himself and others who behaved very creditably. I want to also build on what Lawyer Addo mentioned, to be that most of the time, some of this hate speech and also some of the careless and reckless way the party communicators behave is the result of them believing that they are supported by those who have the capacity to then defend them when it comes to defense. Unfortunately, we are supposed to speak freely, but we should also remember that those free speech would also have implications on us when they infringe on the rights of others. I'm speaking on the side of civil society. We speak freely and we must speak responsibly. For us, we believe that whatever we do in this day and age of misinformation, of disinformation, of AI influencing and affecting policy, we should be doing that on the account of legitimacy. And we do not have to do anything anyhow because we believe that we are going to be supported by somebody, and because of that we can get away with it. I also do not accept the view that whenever people make decisions, in this case the lawyer, he would be making it on the view that he belongs to a certain political party. You know, this politicization of our judiciary has affected our credibility, and we must begin at a certain point to separate careless behaviors from behaviors that are political, and know that wherever we are speaking, we should be speaking from a point of view of people's capacity, people's credibility, and people working with the law. Within the law, we know that when you carry yourself in a certain way, you would be dealt with. As to whether, and again, it says that the judge has interpretative powers. He can do what he wants because the law rests in his bosom. And so in this case, if the lawyer thought that letting the person go as a result of maybe things we do not know of, and you have mentioned that the judge in this case has a background in some of these instances, that is not to discount the fact that sometimes they would make calls which are not correct. But we should have trust in our institutions to deal with the issues that we are dealing with without impugning politics in every activity.
Right.
People may have their political stance, but those stances will not affect every other decision they make. Let us remember that we must be responsible citizens at all times to ensure that we do not falsify information. And it's become a problem in this dispensation we find ourselves, and it's continuing to increase. At what point, if I may ask, would we allow the process to go on without doing this? I am asking, if it were me, I have been affected by some of this in the past, where a whole newspaper decided to cartoon me using NDC colors, and the wind was blowing my dress, and I was in a NDC flagged lingerie, meaning that and some very offensive things, because I had a position that at that point a certain individual had behaved in a way that constituted conflict of interest, and that he was abusing his power and influencing vote buying. That was my crime. And so at a certain point, we must delineate the issues and clearly communicate them freely. I have been at the wrong side of some of these communicators, but that does not also take away the fact that we have free speech. We just have to be able to ensure that we as a people are respecting the laws and acting responsibly taking the politics act out of it to ensure that this country.
So we should trust the institutions, but we should all hold them accountable. This show, as always, is brought to you by the candid sponsorship of Gold Board Jewelry. Pure, precious, proudly Ghanaian. Malcolm, your #1 shopping destination. Waylead, your trusted home builder. Bethel Dental, the smile starts here. St. Thomas Eye Hospital, providing excellence in healthcare. Kel Charcoal Toothpaste, happy smile. Are we getting some reprieve in fuel costs? Here, Comac, right away.
Delayed. I mean, you can attest to the fact that it has delayed from that perspective. However, the new directive, especially that has to do with the negative parts of, or I would say the discounting, has in a way caused some delay in pricing. I myself have received a lot of calls for further explanation. I believe that MP as well. So hopefully everything will be aligned, and as announced, the expected relief will also come. Let me also use this opportunity to throw a bit of light into what has been achieved. Like you put it in your news item about the relief with 36 pesos on petrol and 2 cedis on diesel is true. But let me also highlight the fact that this is a relief that stems from operational margins of activities of the industry. And it has not touched, the government did not touch any tax or levies that goes into the government coffers. But this also means that MPA and even BOST would have to cough external monies to support this. So for me, the question here is that, is this a relief or is pressure on institutions?
Okay, so just a short-term proposal for 4 weeks, but is it not necessary in the circumstances we find ourselves? Yes, Kofi, in 1 minute.
Yes, look, it is a necessary thing for governments to seek to relieve citizens when things like these things happen. But look, since the 70s, when we had the first major oil crisis, okay, from the US and everywhere, the whole world's economy has been at the mercy of the Middle East, countries and what happens in that area. We didn't have oil, and until recently, we didn't even have refining capacity. Today, we have our own oil, we have our own refining capacity, and Dangote has massive refining capacity in Nigeria. What some countries have done is to figure out ways to isolate, not entirely isolate, but some sort of lift themselves away from the vagaries, of what happens in the Middle East. That we haven't done. So this will continue. This thing cannot be sustained. It has to be done. That is relief. But it cannot be sustained. What we need to do is medium to long-term thinking about how we, defend ourselves, or how we, move above a bit of some of the things that happen in the Middle East. And it is possible because today we have our own crude oil, we have 2 working refineries, and we have Dangote next door, and we can arrange a situation that gives more permanent relief than some of these knee-jerk.
Thank you very much. Now, Mary, what do you say? The SOEs that are going to be affected by this relief, BOS, MPA, Petroleum Hub Development Corporation, free fuel allocation for political appointees, free fuel allocation for security services, all of that's gone.
I think it's a good one for all of us. We are all buying, we are all Ghanaians, and I believe there shouldn't be any discrimination whatsoever. If taxes are going, we have margins coming down. We are all suffering. If we are enjoying, we should all enjoy equally. And for me, I believe people have been paid, and those classes of people have been really, really dealt with rightly by the people of Ghana. If you look at their remuneration structures and the benefits thereof. So it is not wrong that as it applies to other public service actors, they are also brought on board now to also share in what we already know has been happening in other public service institutions. We have seen that happen in other jurisdictions, so it's not surprising that some of the institutions who were enjoying free coupons, which also have their effects anyway, you see the misuse, you see it being used. We have done some assessments in the past where you go to assemblies and others where free coupons are given and it becomes the preserve of some people assigning it to party food soldiers and this. So I believe it's a good move. It's for all of us to benefit
and
at
Victor,
the end of the day. Because,
and Victor, the government is taking a hit of about 200 million Ghana cedis every 2 weeks by this.
Yes. And then this has been a short term, and I think that it was a very innovative and creative ways of doing it. It's just like, the price build-up. We were not taking money from somewhere to create another problem. Just like the energy levy, sector levy, that we all agreed at a point that 1 cedi should be added. People were saying that taxes should be taken off. However, if we take that off, the purpose that we wanted that money to be used for, to keep the electricity, we may have created a different problem. For now, I think that it's good, and we were watching. I was a little bit happy when I realized that the Strait of Hormuz has been commercially open. So I was like, it was going to align with what we thought, that we take some short-term.
Closed again.
Now, I've just been told it's been closed again. So we are hoping that things will do. But as Kofi has suggested, we have refineries here. Let's look at it all. I think let's think out of the box. Dangote is just less. Yes, so I will leverage all this. So at the end of the day, it will not be seen that we are always depending on them and there will be problem.
But for 553 million Ghana cedis is what it is estimated to cost us over the period.
Sad as it may be, let's commend the government for the effort it has made. However, we should begin to live for tomorrow. We have become a country that lives by the day, and I don't think it is good. Look, when the Russian-Ukraine war got to its apogee, if you recall, the West then decided to fast-track their energy transition efforts, right? What is our plan? Are we going to continue living like this? We must have a plan. We already have the structures. Historically, we have research institutions. We should begin to invest into them and then make sure that in the medium to long term, we are having alternatives, right? Because
we will expand Atuabo.
Well, if that is going to be done, then that is good. But I'm saying we should, because it looks like this will happen, and then we are sad, and we are threatened, our stability is threatened, and so on and so forth. I think that we should begin to look at medium to long-term investments that will create alternatives to give us long-term reprieve. But finally, as part of the measures, I see that free fuel allocation to government appointees has also been announced as a measure, right, to help, is being dispensed with.
It's being reinforced. It was already announced earlier.
But what previously, when it was announced, it wasn't enforced. Why is it being reinforced? You see, if you recall, President Mohammed's first term, when there was the economic crisis, he said that ministers were, some money was being taken from appointees, if you recall. Then at the end of his tenure, the money was returned to them. So these things, these PR gimmicks, they go on far too often. We need to really look at it. Government must be sincere. With the way he deals with the people to ensure credibility.
Thank you very much. Thank you very much. And my outfits, if you're looking for the best kaftans and shirts like this, the best place to go is Habil's Couture. Just check them out on their socials. Just type Habil's, HABILS, Habil's Coutures, and you'll find them. Their number is 0200 84 1988. 0200 84 1988. Will the special prosecutor be giving the authorization? That's the bottom line of the question. Join me on my favorite show tomorrow at 2 p.m. The Deputy Attorney General, Dr. Justice Fremsai. Many questions are coming up. He will take them up. So we explain this in the law. Quo warranto, OSP. That's the question we are asking. Where is thou authority to act? Thank you very much. Have a good afternoon. My guests have been Victor Kojoga Adaudu. He is with the NDC Legal and Communications Committee. Kofi Bento is a lawyer and Senior Vice President, Imani Africa. Nana Ejay Bafo Ewa, Vice Chair, Subsidiary Legislation Committee and Member, Constitutional and Legal Affairs Committee of Parliament. Mary Awalana Ada is Executive Director, Transparency International, Ghana. Earlier we had Kwabena Bonfe Jr., Doctor. He's lecturer UPSA and CEO of Census. He had to leave us to go do his teaching, I suppose. Have a good afternoon.
Bank of Africa, as strong as a group, as close as a partner. Where Duraplas goes, water flows.
PS Industries has introduced a new roofing system known as Colorlink Plus.
Flamingo paint, simply superior. Syntax tank, are you strong? Are you tough? Cherry Tree Properties. We develop spaces as though we were going to occupy them.
Cadbury hot chocolate, crafted from cocoa, milk, and sugar. Creamy, chocolatey, frothy goodness, rich taste, so satisfying.
Cadbury goodness, the treats you deserve every day.
Hello, good afternoon, and welcome to Sages on the Joy News channel. And you know, on Sages, we engage Ghanaians and Africans, senior citizens who've lived their lives, and they share their experiences with us, what worked for them, but most importantly, how they would want to see this country after they're gone. These are the lessons we learn on the Sages. And my guest today is an engineer, a chemical engineer, Andrew Quison. Good afternoon. Thank you very much.
Good afternoon, Winston.
For joining us. And we believe you're doing very well.
Well, I can't complain.
Great. So let's start this way, okay? Before we get into your professional journey and everything, it'll be important to understand the kind of environment that, shaped you, what the early influences were that set the tone for the person that you've become?
Well, thank you very much indeed, Winston. I was born in Cape Coast on the 18th of September, 1940. My father
1940.
was 40 years.
Oh, that's 85 years ago.
Yes. My father was a civil servant working at the government printing press in Accra. And my mother was a housewife, Mrs. Sarah Letitia Quison, nee Hagen.
Okay.
I lost my mother at a very tender age of 2, so I don't really remember her. And I was brought up by my mother's younger unmarried sister, Auntie Susan Hagen, in Cape Coast until 1950. In 1950, I joined my father in Accra when he remarried.
Okay.
In Cape Coast, of course, I started schooling at Roman Catholic Jubilee School in 1945, and then transferred to Collegon or Roman Catholic School in 1950. I sat for the common entrance in 53.
Okay.
I passed at least the common entrance, and we were invited for an interview at Government Boys School at Kimbu.
Okay. But why did you have to go for an interview? You had passed. I'm just curious.
Well, in those days, when you pass, you have to be interviewed by, I think, the headmaster or teachers from the school that you wanted to go to. I chose Achimota, and I believe, in fact, the panel, I think there were either 2 Englishmen and 1 Ghanaian. Because apparently I didn't do too well at the interview, so I was not taken.
Okay.
My father, in fact, I was very, very disappointed. And my father was then going to the UK on a course, and said that, okay, I'll take you along. So he flew to London, and I, with my stepmother, we boarded MV Accra and left Takoradi to Liverpool. Took us about 10 days. It was a real experience on the boat. From there, I got to London. And London, I enrolled at the school, St. Joseph's College at Beulah Hill in London. It's now in Croydon. This school was founded by 6 De La Salle brothers from France in 1855. It was the first school to be established by these brothers. Now they have about 20 schools in the UK. They have about 1,100 schools worldwide, training about 1 million students. And I must say that the school environment was excellent. I was the only black boy in the school.
Oh. And,
but, the English boys were very kind.
Really?
In fact, they treated me.
In the 50s?
Yes, 1953, 54.
They were kind to you?
Oh, they treated me extremely well, extremely well. In fact, they were surprised that coming from Africa, as they called it, I could manage academically.
Oh, okay. Why were they surprised?
Well, because, of course, most of them hadn't met a black person.
Which means you excelled when you were there.
Well, at least I cooked. I said I cooked. And they asked me, they said that, but, Gold Coast, how were you able? And I said that, there are even cleverer boys than me.
There are brighter students in the Gold Coast.
Than me. In fact, I'm just one of the average ones. They were surprised. I don't know whether they really believed me. But anyway, in fact, what surprised me about the school was that when I was at Collegon, Roman Catholic School, I was relatively small. In fact, the youngest in the class by 2 years. So I never knew that I could even play sports, because the boys 3, 4, 5 years older. But when I got to this school, I suddenly found that, Charlie, I could play football. I could play basketball, even though I was short. I was a sharpshooter. And then I learned how to play cricket.
Oh, okay.
And I did so well that eventually I captained the school in cricket. We had a fantastic victory at the Oval, if you know, over Kennington in London. But even in football, I played for the school first team. And then I was picked for the London Grammar School boys. So I played for the London Grammar School boys. As I said, I was really, because in the Gold Coast in those days, I mean, all they knew was that, yes, Quison was a bit bright. But as for sports, I mean, I don't know.
Okay. Interesting. And I mean, we'll get back to life in England when you were schooling, what you did after sixth form and everything. But you talk about coming to, say, Collegono from Cape Coast. Now, at the time you moved from Cape Coast, there's a fancy boy moving from Cape Coast. You are in Accra, your father is remarried. But then beyond your home, you had to be able to communicate. You're a fancy boy. You've come to Accra. How were you able to cope?
Well, of course, I learned how to speak Ga.
Okay.
You know, in fact, the school was a tough school. I always say that I benefited from the experience at KG Roma. We had boys from Bukom, boys from Koliwoko, etc. And they really tough you. Charlie, it's a new year.
Nakaona.
School, I'm a modern wa.
They toughen you.
Oh.
You engaged in all the...
Because Cape Coast, you see, Jubilee School, I will say that we were more or less daddy boys. You know, all our ages were roughly... I think the oldest boy in my class was just about 1 year older than myself, you know. But in Accra, the oldest, I think, when I was about 13, he was about 18.
You know, like 5 years.
Oh, yes, 5 years. And Kofi Nukwe, so Accra toughened me.
Oh, okay.
And that's why when I got to the UK, I was relaxed, because if I can survive in Roman Catholic school, then surviving St. Joseph's College was really, nothing.
Let's talk about St. Joseph's School, because there you became a leader amongst your peers. What happened? I mean, yes, you're a black boy from the Gold Coast at the time. You get in there, the expectation is because of the disappointment, you're going to study. At what point did you start building the leadership vibes that you wanted to, lead your people?
In fact, when I started performing well in sports, because you see, sports is teamwork. And with teamwork, you really, particularly if you are made the captain. I was, we had the boarding school.
Yeah.
3/4 of the students were day students. And the boarders, we were just about a quarter. And we all lived, together. And what I admired was that the sixth formers in the school had their own rooms.
Okay.
And the head boy at the boarding school, in fact, his room was so nice that I said, I'm going to go to that room. So I became the head boy of the boarders, and as I was the black boy. But, I related well to these white boys.
How did you become the head boy? Were you voted for or you were just appointed?
You were appointed, yeah. In fact, it was the brothers, because in academic work, as I said, maths, I was good at. Chemistry, I was good at. That's why I even chose chemical engineering.
Let's talk about that. I mean, now that you've brought that up, let's talk about that, because you chose to study chemical engineering at UCL.
Yes.
All right, University College of London.
London, yes.
And that's a university that many people would do everything just to get there. At the time when the field was barely known in Ghana, the question is, what sparked that decision and what possibilities did you imagine for yourself and for your country, the Gold Coast, at the time you were choosing chemical engineering?
It was when I was in the fifth form. In fact, it was the time of Ghana's independence when I was in the fifth form. And, you know, the name of Nkrumah, even in London, was everywhere. And people were proud to be African, you know. And Nkrumah wanted to industrialize Ghana. And they talked about the Volta River Project. The Volta River Project, as you know, involved turning bauxite into alumina, then alumina into aluminium.
Yeah.
The conversion of alumina to aluminium, you needed a lot of cheap electricity. And therefore, the project was put up a dam to provide electricity. In fact, at that time, I'm sure that the demand for electricity in Ghana was about 20 to 25%. But once they got the aluminum smelter on board, then the project was profitable. So, you know, I read about this. And then I read about, you know, Ghana industrialized through import substitution. Import substitution basically is producing what you are importing. You know. So we're importing petroleum products, for example, and therefore, so chemical engineering, really, all it is that we design, we develop and operate chemical processes to convert raw materials into usable products.
So if I get you in deciding to do this, having become very proud of everything that Kwame Nkrumah wanted to do, you chose this program to be able to contribute positively to the development of the Gold Coast.
Precisely.
So while there, as a young man, as a teenager, you were thinking about how you could be of relevance back home in Ghana.
Precisely. In fact, all of us, you see, wanted to be part and parcel of this great idea of showing that the African is capable of running his own affairs. You know.
So when you think about Ghana at the moment of independence, at the moment where you wanted to be part, and you know those expectations that you have, how do you feel about the trajectory the country has taken since then?
Well, you know, I came back in '63 to, you know, join Lever Brothers. And indeed, when I came, because there were few chemical engineers, in fact, I think there was one, I think Godfred Osei-Mensah. He worked with Mobile. Then later on, I learned that he had left to Europe to become a secretary for the evangelical movement. You know, so there were a few of us. And in fact, when I came, I got offers not only from Lever Brothers, where I joined, but from GAIP, the oil refinery, and then an offer to go to Moscow to train as an atomic scientist, because Kwame Nkrumah wanted to train Ghanaians to come back and run the atomic reactor. But both the going to Moscow meant, you know, leaving Ghana. Even GAIP, they felt that they needed to send me to Italy for 1 year. And I had even worked at a refinery during my undergrad. So I knew how refineries work. But I wasn't